my lord, the read was fine, pertaining
Make
to.
a mention on Monday.
Okay.
All right.
I don't know.
So these are fresh contempt. Fresh contempt.
Not now. Maybe on Monday.
My lord, readable urgency to kindly list the matter.
You were mentioning this matter. Make a mention on Monday. Tuesday, sorry.
Tuesday mention करिए. मैं कॉल कर. First admission item number 1.
May I please, Lords? Lords, this is the last part of my Lord's order.
Last
Part of my Lord's order, the para 12.
order seeking review.
Yes, madam.
Annexure 5.
Annexure 4, madam.
Annexure 4. You are seeking review of this order.
Yes, madam.
Yes.
Para 9.
Para 9, I am not agree. That has been modified.
You are referring to paragraph
12, my lord.
12.
Before that, Lords, may kindly see para 11.
Para?
11, my lord.
Yes.
Learned additional government advocate representing the state of Odisha has submitted that respondent service shall be regulated in accordance with the government policy, which is more beneficial to her than what has been led by Lord Civil since according to the same policy.
I remember this.
Yes, madam. I am clarifying what has happened. I admitted that there is a government policy. I have annexed that. The government policy says from the on completion of 6 years, he must have the training qualification. Here, he must have the training qualification. Here, he had the training qualification year 2015. But he was appointed as going to say prior to that in 2008. So, on completion of 6 years after training, he will be regularized. That is the problem, my friend. You got my point.
Yes, I got your point. But what about 8 years? Even for 8 years after training?
No, my lord, if he's not trained, then 8 years in the ex-cadre.
Then we will have to hear him.
Yes, that's
File a reply. File a reply.
Now she has been suffering for last so many years. Without recording my constitution, even if they say it is let it be done because so I am not getting a single file of the benefit of my
Do it.
yes, ma'am. That was
Do it whatever you want, then we will see.
No, but let them at least do that. I am not getting
Let's do it.
single file.
Whatever you want to do it.
from 2017 we can regularize.
You give her, file an affidavit, and then according to him, we will see what can be done.
Yes,
That's something I will be satisfied.
that is also
Let us
Yes, ma'am.
let us give quarters to this district.
yes, ma'am. We are ready to regularize.
Do it.
I will get something.
Do it. Do it as you wish. The state is seeking review of an order of this court dated 26/4/2024, passed in WA number 1912 of 2023, operative portion of which reads thus. Relevant portion of which reads thus 11 and 12. So stop. Mr. Kutial and AGA appearing on behalf of the petitioner has submitted that the respondent shall be entitled to regularization upon completion of 6 years from the date of
Acquiring
training, the
training qualification.
date of acquiring training qualification. So stop. Let
Let's
be done.
let's not
Next.
sorry.
Let that be done. So stop. List this matter on 1 week.
What I am by that process, she will be sufferer. What I am submitting, madam. If she will be regulated against ex-cadre post, will be regulated with effect from 1/3/2017.
So whatever you want to do it.
So that,
All right.
yes, ma'am.
So let us close the litigation for all times to come.
Without recording my
All-
constitution, I-
All that we are not saying that.
Supreme Court has clearly settled.
Yes, the Supreme Court, in academic, 6 years, so it will be suffered if 6 years.
one after another, they are filing and that's stopping.
All right, now it will not be. This will be the last thing.
Item number 2.
I don't know. I mean, for me, the records yesterday, because of the today morning, I have received it. I have gone through this.
No, not conducted by virtue of the deposit units. You have to pay the remaining amount around 50,000 so much with interest units. But till then, they have not perhaps paid this and
A payment, I was 6 months information, I pay not taken
that's fine.
I pay not taken some yesterday, because I have not gone through this question, because I have lost my bill, but my client lost my money, but I have not gone through this, so I pay not yesterday.
At whose instance the matter has been listed?
But I have not gone through because of my emails, I have not gone through, I have taken permission from my friend.
I requested on behalf of the petitioner, list this matter on Friday.
Next,
Item number 3.
Please do it.
madam.
50,000 is to be given according to you.
Yes, sir.
Plus interest.
Petitioner in person.
I will propose the will.
Here is the order. The WA number 1737 of 2022 was dismissed on account of non-appearance of the appellant who had filed the appeal in person. That's all. Considering facts and circumstances and the reasons stated in the application, this application has been filed for restoration of WA number for to its original file. Considering the amendments made in the application, the same is allowed. This case, the same is allowed. Let WA number be restored to its original file. Yes.
Item number 4.
Yes, it is called.
May I please, your lordship, item number 4. May we permitted to decide.
Withdraw.
Item number 5.
Oh, bless me.
May it please your lordships. This review arranges to review the order passed by this honorable court on 14th of December 2023. There is Annex 1. Whether the facts are,
No, but what is the
that is an error.
14/12/2023?
23. Whether there were 2 orders of this honorable court allowing by writ petition, that is Annex 4 of the same SSC, only different assessment here, that is 15/16. Whether
See, the writ petition was dismissed on the ground that you had alternate.
Alternatively, that is what my challenge is. Because these honorable court mallards failed to. I have placed the order of judgment of this honorable court of the same assessee. Only
Not the question. The question is that if the order is not in accordance with law, then you can challenge this order.
mallards.
But he cannot say that this order is.
I am saying why mallards? Because the honorable, this honorable court mallards, with great respect, did not follow the ratio of
Cannot be gone into. This is a review jurisdiction.
I know mallards. Mallards, recent judgment of the Supreme Court, so far as review is concerned, mallards, is there, mallards. I want to bring to a lordship's kind notice by Justice Bella Trivedi. Ghanshyam Mishra case was sought to be reviewed. That was refused only on the ground that when a reasoned order has been passed by a coordinate bench, that should not be commented upon by another
This
coordinate.
is what we are saying.
Yes, mallards. Now, mallards, this is totally mallards and unreasoned order.
Therefore,
Mallards may kindly see.
challenge this.
Mallards, Lordship may kindly see. One thing Lordship will agree that a writ petition having been entertained by the Honorable High Court, the similar writ petition on the same facts cannot be dismissed. That is, mallards, where 87 Supreme Court.
We are not commenting upon, or we are not forming any opinion on whatever submission you are making,
Yes.
because we cannot answer those questions.
No.
We can answer those questions in one line, that those questions can be raised before appropriate forum, not in review jurisdiction.
Mallards, so far as the law laid down by the Supreme Court is concerned, mallards, that is where 87 Supreme Court. But once on the identical facts, the honorable, then there will be mallards. What will happen? There will be a chaotic situation. One bench says, yes, repetition allowed. Another bench says, dismiss.
That may happen, but review is not the forum.
Mallards,
That is the question. That is, you can.
mallards, if the review is not, the forum will be mallards, the apex court. There is no other forum. Because apparently, on the face of the order, mallards, on the face of the order, that stands, whether it doesn't, it does not fit it. So far as the law, that is the lordship's prerogative to entertain or not to entertain. But the question is, my lords, lordship may say that the judgment or the ratio decided by the Honorable Supreme Court after the new regime of the Income Tax Act came.
Mr. Ray, we learn from you, members of the bar, and as the members of, as being the members of the bar also, this is what we have learned. The limited scope of review.
Correct.
So while exercising that jurisdiction, we cannot say that any finding.
Lordship cannot excel the power of appeal. That is correct.
Exactly.
I entirely fully agree.
This is what we have learned from you.
This is the law. That while reviewing an order, the Honorable Court should not sit in appeal for to exercise the review jurisdiction.
This submission we will record in our order. The submission which you made will record in our order.
No, sir. That is the law.
That is our opinion.
I am not telling of my own. This is what. But Lordship may also record. If your Lordship is recording this.
I will not record your submission. We will record our finding, our opinion on the basis of.
Very good, balance. Then Lordship may also see one thing. That whether the order passed by the coordinate bench is not in conformity because of the judgment of the Supreme Court in Union of India Assist Order. Unless you, I explained to your lordships the new tax regime which came into force.
Sorry.
That is, my lordship, kindly see.
Sorry. Sorry. The petitioner in the present review application has sought review of an order dated 14/12/2023 passed by a coordinate bench of this court, which reads as under. Stop. Mr. Siddharth Ray and senior counsel appearing on behalf of the petitioner has argued that in similar set of facts, in other cases, different view has been expressed.
Similar facts of the same SSC
All right.
for the assessment year 15-16.
This. No.
Seek alternative in that. So, remedial forum, it can place the same judgment from the.
This is this one. That's and you already did. And senior counsel appearing on. Stop. He has made certain submissions to question the correctness of the order which is under review. Stop. Next. In review exercising review jurisdiction, this court cannot sit as an appellate authority over an order passed by a coordinate bench of this court. Stop. We do not find any reason to interfere with the to review the said order dated 14/12/2023. This application is accordingly dismissed.
That's all right. But may I say one thing? Thus may also record that my submission that once a writ petition has been entertained by the High Court, by coordinate bench, then another coordinate bench cannot dismiss it. That is AR 87 Supreme Court, page 1375. That is Brajan Lal versus State of Punjab balance.
That once a coordinate bench. This is what we have recorded already.
No, that decision and lordship have not recorded. AR 87 Supreme Court, page 1375. Back front.
Coordinate bench. In another case, different view has been expressed. And the
Brajan Kumar
and the had been expressed.
versus State of Bihar. That is my lords, AR 87 Supreme Court, page 1345. I stand corrected. 1345.
The order needs to be reviewed. He has placed reliance on the Supreme Court's decision in case of science.
Lordship, in this case, that order is actually alternate remedy which was provided was correct because the facts in this.
All right.
Item number 6.
6, 7, and 8, same balance. Only parties are different and
Same.
different assessment here.
Item number 9.
Mr. Naik,
Nine, you are seeking adjournment.
my lord.
Why are you seeking adjournment?
My lord, the arguing council suffering from dengue.
Where you are arguing counsel?
Mr. Naik, sir. Suffering from dengue heavy fever. So I pray for next week, sir.
You should not worry. Why is the order suggesting?
This is to the. This is to the. One is the.
Delay.
140 days delay.
This was. No, we will not do it, mister.
My lord. My lord, let it come the next week, my lord.
We will not do it. We will not do it. The present application has been filed for restoration of WPC number 11032 of 2015. What's off? Next, we have 2015. By the said order, the writ petition was dismissed for non-prosecution in the absence of any representation on behalf of the petitioner. So next, we have perused the order sheet of WPC number 11032 of 2015. From the order sheet, it transpires that almost on each and every date, the petitioner either sought adjournment or date prayer was meant for adjournment of the case, or there was no representation on behalf of the petitioner. First off, because of a repeated absence for my adjournment, the writ petition, which was filed in 2015, was earlier dismissed by an order dated 22 to 2024. First off, subsequently, the petitioner filed an application for restoration giving rise to CMA PL number 256 of 2023, which was allowed by an order dated 21/4/2023. And accordingly, the writ petition came to be restored to its original file. First off, again, on 4/8/2023, the writ petition was adjourned. First off, on 5/12/2023, there was no representation on behalf of the petitioner. First off, there being no representation on behalf of the petitioner, the writ petition was dismissed. First off,
Item 9,
we are not inclined to restore the, we are not inclined to allow this application in view of the facts noted above. This application is accordingly dismissed for default.
Item 9, my lord.
Yes, we have dismissed.
Well, can't hard me, my lord.
Yes, say.
My lord, I have filed the booklet now.
What?
I have filed the power of booklet now, here. But my lord,
Yes,
I have filed the booklet number 24/2023.
yes.
But my name is not reflected in the court title.
Today,
No, my lord. the date can be dismissed on 5/12/23, at page 891.
Just a minute.
Page 9 of the last matter.
Annexure 1 of
Annexure 1 of the CMPL petition. Page 8 and 9. This is the call list I have downloaded now. Will also come to page 9 now.
issue notice.
Hello.
Just a minute. Why every time you were absent earlier?
No, my lord, I have not absent.
Yes, you.
That is my name is reflected.
Mr. Counsel, this time your name was not reflected, but
That is my lord. That cause list I have annexed, my lord. This is the call list of
all right, you should.
That was registered at D number, diary number was registered. Some defect was pointed out that a copy has not been served on the state, though the state was not a party. That was it was directed that
State is a party in all contempt.
yes, madam, that has recently been developed, madam, earlier we were not filing.
No, that is no question of recently been developed.
Yes, my lord, I am not saying that. My lord, we have rectified that. My question is, my lord, that it was fixed to 30th of May 2024 for removal of defect. That was the summer vacation period, my lord. After the reopening when you went, they said that it has been dismissed. I filed an IA for restoration that may be taken for orders.
IA for restoration.
Yes, because that order they have dismissed by themselves. But the office has dismissed it by the registry. So I have filed an IA for restoration of that contempt petition.
How can you file an IA which is not there?
I was referring to that matter because ordinarily had it been dismissed after the registration, simply I could have filed, my lord. But now, my lord, since it has not come to the registry before my lords, it has not been registered.
Instead of filing your CMPL or IA, you could have filed a fresh contempt application. What is wrong?
I was in a, because that was dismissed during the vacation when the court was not coming, we were out of the station.
All right.
So when you came, by that time it is already dismissed.
I'll take care of that situation, but better you file a fresh application, make a mention, I'll look into it. Let us follow some system. All right. Let us bind ourselves with,
Yes, but
with procedure.
well, usually I would have filed because I am agreeing with my lord. But the question is, my lord, during the vacation that could not have been dismissed.
Senior counsel, I understand everything. The place where you were, they were, all of them were there. I was also there.
Yes, but your lordship have come from this side.
Therefore, I understand everything. Therefore, I would rather, in such case, in fact, I intend to take some decision on that regarding dismissal of applications where the defects are not removed. I am in the process of taking some decision. But better you do that.
Yes, ma'am.
All right.
I am not difficult of filing that, but I wanted to bring this fact to my
It
knowledge.
is good that you brought that to the court's notice. I'll see that at least the during this vacation brought it.
Because no court was,
And even otherwise, I'll do something.
With your lordship's kind indulgence, may I mention the arbitration matter, my lord. Here, my lord, pleadings are complete. Privileged.
I have filed an IA to prepone of the hearing. For that, prepone of the hearing, that was
IA for
prepone of the hearing.
preponing.
Preponing the date of hearing, my lord.
division bench.
No, my lord, single bench.
Date of which hearing?
Of a CRLA matter, appeal, my lord. Some of the co-accused is already released on bail. But I have mentioning,
Before this bench.
no, my lord. Before,
Make a
coordinate.
mention before
But
application.
I have mentioned, but that could not be. No,
I don't have appellate jurisdiction, you know, on mentioning.
my lord, but I have mentioning before all the benches and also DR. But that could not become as because
Why did you make a mention before DR?
because in the meantime 3 benches has been changed. When I mention it is allowed and the next week the benches has been changed.
That is your misfortune.
Well, kindly next week, my lord.
Will not be in a good taste.
May I pardon to mention also, item 753 also. 753 also. In that matter, I will file an additional affidavit. The matter is in list. The affidavit is could not tag that in that file also. I will let it come next week along with the affidavit also.
So whether order has been complied with or not,
Also, I will
let it come into 735 is not going to be taken up today.
that's right.
All the cases are on the list. Create a pressure on all the contenders.
But
You know that any time the matter can be taken up and they can be.
but what if I will bring this facts should also to
Do that. Who is stopping you?
but that affidavit could not tag in my file.
That Mr. Counsel,
There is no nothing or
why are you making this mention?
So item 489. So I pray let it be taken up to the my lords, because even after a dismissal of the SLP, they are not complying the order, my lords.
All right, wait.
My lord.
Please, they will comply with the order.
My lord.
My lord, item 225. In this case, I have petitioned that I have had a substitute petition. I number
Let the matter be taken up.
262.
Let the matter be taken up. Further mention.
My lord, 132, my lord, there is no instruction. Item 132.
135.
132. 32.
No is 132. No instruction I am complied with. Those mentionings can be entertained.
Pardon to mention, my lordship, on 12th July, last week, my lordship, I have mentioned 3 memo regarding 3 contempt petition. And as per my lord's direction, I have handed those 3 memo to the London State Council to peruse the record and to list the matter. But
No, not to list the matter. I had asked you to give him.
my lordship.
I will look into it.
My lordship, these contempt matters may be listed on next week, my lordship.
So 1,500 cases you want to be listed. Already 1,000 cases, more than 1,000 cases are listed.
My lord,
I don't know how many cases I am going to take up.
my lord.
Let us see. Just try.
My
My lord, I beg your lordship's pardon.
Pardon, my
My lord, item number 632.
Item number.
My lord, here
418.
the SLP preferred by the state government was dismissed on 6/5/2024.
All right.
Yeah.
Therefore, your case is there on the list.
Yes, my lord, but 2 months in the meantime passed. I pray, my lord, let it be next week. Let them obtain instruction
I
regarding
don't know.
that.
Every case is urgent. Which case is less urgent? Tell us. Tell the
My
court.
lord, my lord,
that
it involves, my lord, it involves some
Everyone's case everyone's case is important for the court.
Lordship, item 88. No instruction. Item 88.
Partner item number 61, no instruction, item number 184 and 85 complied with.
Yes.
Pardon to mention, my lord, item 133, my lord. Can you pardon to withdraw, my lord?
Item 7, my lord, no instruction. Item 7.
What?
No instruction, my lord. 7.
Item 13, my lords, Infructuous. 13. Item 81 also. No instruction, 81. Item 140. No instruction.
Item 103, my lord. Complaint, my lord.
Hello, item number 171. Permitted to
Number please.
171. Item.
Lordship, item number 15, it was written in instruction. Item.
My lord, item 178 and no instructions here.
Item 334, complaint, my lord.
I may be pardoned, my lord.
22, no instruction.
Yes.
My lords, I may be pardoned, my lords, item 418. My lords, fresh matter. My lords, I pray for let notice be issued.
Not
My-
now. Not now. Yes. Yes, why is
Look, read consultants item number 2.
2?
Yes.
So,
I am on virtual mode. Item number 10 has become infructuous.
Item number 2, sir. So item number 1.
Lord, 1 is compliant.
Today itself, the order was passed. But there is one problem, Your Lordship. The name of the petitioners are not recorded in the name of the ROR. In the ROR.
The ROR has been prepared in terms of the civil court decree. Your Lordship may remember, there was a civil court decree. The court's direction that whosoever are the decree holders of that particular suit, the Tahsildar has recorded their names in terms of the.
These legal heirs may record their names.
No, legal heirs cannot be recorded because they are not.
no, you can do whatever you want.
Yes, because of law.
The petitions will be at liberty to take the course to further action if so required.
You also indicate that. You also indicate
Further
that.
action. that-
Yes, yes. Very good. Right.
Item number 2. The continuous attendance to the external side, high two applications for issuing applications. One was for the defense in the personal activity. And the other bringing the lawsuit notice that SLP is going to be prepared and going to be filed in the course of the day. If they also may upload it from the day only so that the content of can be present on the day, you could file it.
So when was the order passed?
Because the order was
7/3/2022, my lord.
7th of March 2022.
Where is the order?
No, that is page 14, paragraph 8, the operating partners, page 14, paragraph 8. Having heard from the counsel for the parties and upon consideration materials on record, this court is of the view that the petitioner is eligible under the scheme floated by the Finance Department dated 15/1997. And accordingly, the service of the petitioner should be regularized by now. However, ignoring the case of the petitioner, his juniors have been regularized is evident from the record. In summary of the matter, this court disposes of the repeats of the direction to the open number 2.
When was the order passed? 2022.
My lord, 7th March 2022, my.
Come forward. So when were you posted? Since when you are holding this office?
31st July 2023.
31st July 2023. Who was your predecessor?
PK Nayak.
Huh?
Pramod Kumar Nayak. Pramod Kumar Nayak.
Pramod Kumar Nayak. So I am taking you into custody and giving him an opportunity to impeach Pramod Kumar Nayak. His personal attendance will also be required on the next date. And you may do whatever you want. Call the sergeant. No, call the sergeant. Sergeant. No, I will release him on personal bond. He will be released on personal bond, but right now I am taking him into custody. Is a 2022 order that has not been complied with, and in 2004 July you are taking this plea that you are going to file a case in Supreme Court. Very good. बोले? No, marshal नहीं है हाँ. पुलिस वाले नहीं हैं हाँ? No, DSP and nothing. The prison contempt application has been filed alleging disobedience of this court's order dated 7/3/2022, passed in 3350 of 2022. The operative portion of the said order reads as under. Have you filed any so calls?
Yes, I filed a so called.
When?
Yesterday only a so called will be filed.
All right. It is an admitted fact that the said order of this court dated 7/3/2022 has not been complied with. The present incumbent of which post?
Engineer in chief.
Engineer in chief.
Engineer in chief.
Engineer in chief, rural water supply and sanitary, Odisha is personally present. First off, he has informed this court that he is holding that post since 31/7/2023. First off, before him, one Mr. Pramod Kumar Nayak was working as so and so. So it is also not in dispute the order of this court, violation of which has been alleged in the present contempt application, was to be complied with by the chief engineer rural works, rural water supply and sanitation, Odisha. So stop. The court takes serious note of deliberate disobedience of this court's order passed more than 2 years ago. So stop. Next, it has been stated by learned AGA that a so-called reply has been filed yesterday. Yesterday. So stop. Hey, report pe hai wo?
Not that.
The said affidavit, the said so-called reply is not there on record. What is your stand?
Yes, we have taken a standard, so we have already not proceeded file and we can.
So you make it clear that when the order was passed in 2022, you did not have the intention to comply with the order.
Right.
All right.
Yes.
In 23, you did not have the intention to comply with the order because you wanted to prefer an appeal.
Yes.
And in 2024, you intend to you were going to file an appeal. So therefore, you did not have any intention to implement the order for all times to come. So contempt is that is proved. Punishment part, in fact, the so-called reply is not there. I am adjourning in for next Friday. Next Friday, counsel for the petitioner is permitted to impeach Pramod Kumar Nayak. Pramod Kumar Nayak, the former so-and-so engineer in chief. So he shall be required to be present on the next date, Friday, with his so-called reply as to why he should not why a contempt proceeding should not be initiated against him and he be not punished for deliberate disobedience of this court's order. So list this matter on 1 week. In the meanwhile, I'll next day I'll take both of you into custody. This is too much. This is too much. And if so far the message has not gone, then I am very sorry. How dare you can? All right, we'll see on the next Friday. Only because the so-called reply is not there, I did not have the opportunity to see that. Otherwise, I would have taken you into custody today itself. This is not done. How can you take the court orders of the court so casually? What did you do? What did you do after the order was passed in 2012 when you resumed office and joined on 31/7? What did you do?
We have asked instruction from the government.
Instruction from the government when? Do you monitor the cases in which the contempt applications have been filed? Do you have any system of monitoring cases? And this is why so many cases are pending. Do you have any system or not?
Yes.
Then be ready to face consequences. Be ready. This is too much. You take these orders, the court's orders so lightly. Are you above the Constitution? Only because we are not taking strong action. All right. We'll see. Next.
Item number 3. Item 3 for information is an option. Item number 3, university matter. Members said that salary company for the public the salary amount was quantified and has been released on reduction of the income tax contribution and has been released started.
Everything has been done.
No, gratuity amount, monetary release matters, gratuity amount only release, and it's that total election. Permit me to show my lord. My lord, this amount that they're saying right now, a notional amount has been drawn at.
Just a minute, let me see the order.
Your lordship. My lord, 2 orders, 3560 your lordship will have.
No, the order violation of which has been erased.
Yes, my lord, 3560 and 3561, 2 contempt applications are there. Of the year 2000.
No, where is the order? Let me
Page 12 and 3560 it starts.
What is the order?
My lord, page 21, that is at page 10. But the benefits that were given to the petitioner prior to its assignment would be given back to the petitioner. My lord, and these included the half-earned leave, the EOL, and the other things.
You are reading page?
I'm reading from page 10 in.
Considering the rival contentions.
Yes, my lord. And somewhere the direction starts from the middle. This course here takes into account.
Just a minute. What is the direction?
Yes, my lord, that the benefits that were given to me prior to that being resigned.
Council, where is the direction?
My lord, the last lines, your lordship.
Read it.
My lord. This court, while deprecating such action, for there is no observation of principles of natural justice, finds the impugned order remains unsustainable. This court accordingly quash annexure 2, petitioner be treated to have enjoyment the benefit as with the issuing of annexure 2.
Yeah.
Yes, my lord. My lord,
there is no specific direction.
No, my lord, the annexure 2, your lordship may kindly see. I filed it in my rejoinder affidavit. My lord, may kindly see what was that annexure 2?
Yes.
Page 8. Next up to page 8. This is the order dated 18/6/1998 that was granted in my favor, and your lordship will see at page 8. Page 8, your lordship, annexure 5.
Yes.
My lord, these are all the ELs, the half-pay leave, the earned leave, and the increments and the pay return were directed to be given to me.
Also, there is direct Supreme Court decision.
Your lordship.
That even if an order is passed,
My lord.
unless there is specific direction,
My lord.
the contempt court should not proceed.
the petitioner will be paid for the benefit.
Has not been paid to you.
These amounts have not been paid.
Which amount?
My lord, the earned pay leave, the half leave, and the other things, your lordship. I'll just
Yes,
state
but one second.
with due respect, my lords. He was on unauthorized action for 5 years. This period was regularized, giving them almost HPL and thereafter much residual period is 2000 EOL. That is what it will be in continuity in service. So that the suspension period it will continue and he will be entitled to get the last paid done. That is what it has been adjusted and been extended to him. No.
So you have complied fully.
Yes. That is what my
So there is no effect of this office order.
No, there is no effect. I will be filing my own friend says, I will give you the detail and doing it.
Do it, otherwise the vice chancellor will,
So for that, Vice Chancellor, madam, this is one. And madam, there are two more parts.
we don't know the registrar.
Yes.
I know the vice chancellor only.
The register of the university is the head of the institution.
No. Vice chancellor is the head of the institution.
Madam, the Vice Chancellor has filed the directive reply. These period, minus 5 years, I will give in detail. The 5 years period has been treated and then benefits have been
I will
extended.
satisfy him.
Yes, my lord.
Yes.
I have stated that in so called, but I will give in
Let me
detail.
see, let's just caution them. This is the court's advice to you.
Yes. So far, the second item is concerned.
Yes.
So, but the second item, there minus, you have extended the veteran benefits because he is under the scheme. He is entitled to gratuity, he is entitled to months CPF.
Yes.
We have released and salary component what minus. No, that was minus. They have taken a notional amount of 28,000 minus. I have given a specific calculation.
Next Friday, I'll hear it. And if I have both the cases and if I am satisfied that any part of the order has not been complied with fully,
Yes.
and if because of that, he may have to approach the court again. The court will
No.
initiate contempt proceedings. All right, against the vice chancellor,
I find the
not against the registrar. Registrar may also be proceeded.
I filed minus compliance affidavit. It will be taken into record minus.
I will see it.
It is, I respect that filed that. In,
Students, yes.
item number 4. Grateful election.
Item number 4, the order of the Honorable Single Judge has been partly complied. He has been re-engaged. He is getting the salary. And so far as the regulation is concerned, that part has not been complied, but he is getting the salary every month and he has been re-engaged. That is, I have got the instruction that they will examine this point whether regularization is possible or not, or if
When was the order passed?
Also, kindly see page 18.
When was the order passed?
23/8/2023.
August 23.
Judgment was passed, my lord, on 22/8/2023. The petitioner retained in 2001, keeping his juniors in service, 40%. After that, 26% retired and died, only 14 remain. In contempt application, they say these 40% are eligible for the appointed minor. Thereafter, they have not complied. I filed the root application. Here, your lordship director paid in minor.
All right, see, the court is bound by the law, which
Yes,
the order which has been passed,
Hello.
they will have to comply with.
My lord.
But I must say that law of regularization is in Odisha is different from the entire country.
That is the judge order, my lord, to regulate their service. Your lordship, I am just reading the operative
Yes.
person, my lord.
Yes.
Your lord, page 18, my lord.
Yes, what do you propose to do?
My lord, 2 weeks time may be granted. Within that period, whatever possible, we will do it.
All right, as requested on behalf of the estate, list this matter on 2 weeks.
Item number 5.
Item number 5. That's a writ appeal bearing number 1905 of 2024 has been preferred against the order under single judge. Because they will also take it up this writ appeal next week before the division bench. And ultimately,
No, when the appeal has been filed, then no contempt. Why contempt?
appeal number 1905.
Appeal has been filed after 8 to 9 months.
So what?
My lord, earlier, the honorable court, coordinated bench of this honorable court, relying the direction of this court, unity of the petitioner, directing to regulate the service of the petitioner, order was passed. To pay the unpaid salary, which I have received before regulation. The regulation has not been paid.
List this matter.
And your lordship kindly may.
List this matter after disposal of WA number,
WA number 1905 of 2024.
which is said to have been filed against the order which is impugned in the present contempt, which is violation of which has been alleged in the present contempt application. Yes.
Item number 6. Item 6.
On appeals.
Item number 8.
Dismissed.
Item number 9.
Nine dismissed.
Item 11.
Dismissed.
Item 12.
11 and not no instructions.
No instruction. 11 no instruction.
Item 12.
Dismissed.
Item number 14.
Opposite party number 2.
Complied with. Dismissed.
Item number 16.
Dismissed.
Item 17.
Dismissed.
Item number 18.
Infructuous.
Infructuous.
Item 19.
On appeal.
Item number 20.
Complied with. Complied with or not? Item 20. What is the order? Where is the order?
Well, already at page 14, madam.
What is that?
And that delayed applicant disposal the direction to opposite party to take immediate steps for payment of salary to the members of the staff of Jagatpur High School in a period of 2 months from date of receipt of this order.
So what is your instruction?
No, it's
Not complying.
What is your order?
Not got anything.
They have not been paid. File so called?
Yes.
Yes. The proposal reply we filed on behalf of the contempt as to why contempt proceeding may not be initiated against them for intentional disobedience or court's order in the Yes. 2 weeks. 2 weeks. Yes.
Item 21.
We have complied with that. We have complied that.
Compliant. No one appears. Compliance affidavit has been filed. It's in full compliance of this court's order. So, contempt proceeding drop. Yes.
The connected one. 640.
Both are connected.
Yes.
Item 23.
Yeah, madam, compliance affidavit has been filed.
Compliance affidavit filed. No appears. Yes.
Item 24.
Now, as this contempt petition was against an interim order, the writ petition has already been decided it has become now infructuous.
Item 25.
No one appears.
Item 26.
No one appears.
27.
No instruction.
If any call of action are then
No instruction.
Item 28. Item 29.
For the opposite party number 1.
Present. Yes.
Item 30.
item 29.
Sir.
They are not filed so called.
Yes. Why don't you tell me that?
Notice was issued 10 years.
He is present. कोई appeal कर रहा था. Who is for the other side?
Item 29.
The notice was sufficient.
29 my lord, in fact, the file is not not available, therefore I am not.
What is the direction? Let me see. What is the direction?
You are hearing a case, my lord.
So what is the direction? Where is the order?
My lord, your lordship kindly see. Direction was in first appeal, my lord, 185/97. Annexure to page 12. At page 52, my lord, direction. Accordingly, my lord, your lordship kindly page 52.
But how contempt will lie? This is a decree.
Is a decree. And thereafter, my lord, original owner executed to received, my lord, amount to sell the property to two persons. Now is the first agreement, I already paid the amount.
No,
Instead of notice, the second person,
this order was passed in first appeal.
yes, in the appeal, first appeal.
So
My prayer was a kindly.
lie under the Contempt of Courts Act.
Here is the case, my lord, where in spite of direction, they have pursued the matter and we are in the infructuous suit. The
How contempt will lie? Contempt will not lie, Mr.
counter claim, my lord, counter claim, suit was withdrawn. And we had the second,
So you have filed your contempt application under 250, not under the CPC.
yes, even they pursue, in spite of that, they say they are going to the Supreme Court. And they are not going to Supreme Court, my lord. They persuaded the matter and civil judge senior division.
This is a dispute between you and a private party.
Yes,
There is a decree.
yes,
There is a procedure prescribed for execution of the decree.
yes.
Then why contempt? Otherwise, this court will start executing orders passed by the
Single elastic can see the prayer. The civil judge senior division, in spite of knowing that there is no.
You want the court to initiate proceeding against the civil judge.
Yes, I have said, I am, that's why I answered. I am not asking to your lordship, can see the prayer.
You are maintaining, see, we are not, we don't have to see the prayer. We have to find out whether the order has been violated.
Yes, the order is violated
by a person.
Yes, the order is violated in the sense.
Who has violated? The first question would be if the order has been violated, who has violated?
Violated senior division.
He has violated.
Yes.
So he has immunity.
Then that's why I wanted a permission. Prayer, your lordship,
We cannot entertain that prayer in this country.
Supreme Court decision, my lord.
Yes.
I have to take leave from your lordship. That's why my prayer is.
You cannot take leave in contempt proceeding. These are the matters which deserve to be dismissed with exemplary cost.
Yes.
What are you doing?
I am just pointing out to your lordship. On the basis of the Supreme Court decision, 2011, volume 6, page 385.
Yeah.
In that way, your lordship. Page 10.
Yes.
And further play, subsequently, further play the honorable court to allow the petitioner to include the one civil judge senior division Barbada, Srimati P. Saha as party in this petition.
Which petition?
In the petition, that here.
Contempt.
In the contempt, I wanted your lordship, petitioner to explain about her order dated 15/7/2014, passed infructuous counterclaim petition in disregard to the judgment dated 25/10/2013. The direction, 25/10/2013, the direction was
If there any law has been let down that a judicial officer is, can face contempt proceeding for any action taken by him.
contempt, I cannot expect contempt directly.
Then
I can draft your lordship notice. This is the order passed by the one civil judge.
to the court's notice by writing a letter to the Chief Justice. All right, but not in contempt proceeding. Judicial officers can be, should they be proceeding for contempt?
Judicial officer, my lord, it was brought to the judicial officer. This is the direction of the Honorable High Court. And in spite of that, without my lord taking it to note, she has passed a decree contrary to the direction of this Honorable Court. That is the issue here involved. They are not filed so called.
I'm not satisfied. Dismissed.
Item number 30.
Yes. Dismiss, sir.
Item 31.
Even while I'm appearing for opposite part number 1, my lord, the order has been completed.
Complied with.
Item 32.
On appeals dismissed.
Item 33.
Dismissed.
Item number 34.
Non-compliance of order dated 11th April 2014, a lot of page number 80. Relevant person considered
Order being complied with or not?
not compliant, so was not filed. Not compliant.
Actually, we have some time to file so called.
Why should we grant time? Why? This contempt petition was filed in 2014 and you don't have any instructions. And this is despite the repeated notice by the court that these are the cases which are going to be taken up. Ask the Chief Secretary to join the court proceedings at 2. We call it next Friday. No, sorry. Still not done. The present contempt application was filed in 2014 after serving a copy 14. A copy of the contempt petition was served on counsel for the estate under the order of this court on 16/10/2014. Stop. By an order dated 19/3/2015, then counsel for the estate was asked to seek instructions. Stop. Then AGA representing the estate has submitted that it does not have any instructions and he wants time to seek instructions. Stop. The court has noticed in many of such matters which are pending for more than a decade, where the State Council has not been able to seek instructions and file so-called reply in a reply in contempt matters. Stop. This matter. Stop. The court will take up this matter again at 2 p.m. Stop. The Chief Secretary, Orissa, shall be required to join the court proceeding online at 2 p.m. 15 p.m. to 15 p.m. Yes.
Item number 35.
It is not expired, my lord.
Fine.
And needs substitution.
Substitution, where is the question of substitution in contempt matters? Let me see.
Because my instruction, the order has been complied with.
Order has been complied with. Complied with.
36.
36 lot no instruction. I may be
Instruction.
leave may be granted to move if cause of action survive.
Item 37.
It only comes in.
No, appears.
Item number 38.
38, I am for the opposite person. Madam, in this case, I have a compliant with them. And moreover, my understanding that the petition has already been expired.
Complied with.
Item
As stated
13.
by Land Council of Contempt. Yes.
39.
Order not complied. Order dated 24/3/2014.
Where is the order?
Order is 25/3/2014. At page 2, paragraph number 2. No, I have not the file, but I have searched from the laptop. The order is quoted.
To representation disposal.
Yes.
Oh. On. Why have you not annexed? Yes.
No, sir. My friend has window note copies now therefore, but he says that he is going to get some amount from the where he is retired employee, so that age is more than 62. But not so. There is no instruction because we are not.
Have you talked to your client?
Order not, yes, I have obtained instruction, order not complied.
All right, 2 p.m.
Item 40.
No, yes.
Item 41.
No instructions.
Item 42.
No instruction.
No instructions.
43.
No appears.
Item 44.
No appears.
Item 45.
Item 45, my lord, in the meantime, we have filed affidavit. It has all the orders have already been complied in the meantime.
Item 46.
Obliged.
No appears.
Item number 47.
No appears.
48.
No appears.
49.
49 also received no instruction.
No instruction.
Item 50.
No appears.
51.
51 minute, I am offering for the opposite minute. Already complied with minute.
Complied.
Already complied. And this is my compliance affidavit focus.
Item 52.
51.
No instruction.
Item 53.
May I please, lords? Order dated 4/7/2014 was a challenge, but the Honorable Supreme Court has stated the matter that the order will not be implemented. And the order will not be implemented till disposal of the SLP. So matter is pending.
It will become infructuous in the Honorable Supreme Court's order now.
How? The Honorable Supreme Court, by written order, passed that order, the implementation of the interim judgment shall remain stayed.
The remains in contempt proceeding cannot proceed, no?
In the contempt application, order has been passed. And because you have to kindly see the contempt.
Whatever, in the contempt application, the order has been passed, but deliberate disobedience is not made out. Let that matter be disposed of. File a contempt petition. We will see.
Liberty may be given.
And counsel for the petitioner, after some argument, seeks permission to withdraw this application with a liberty to come again, depending upon the outcome of an order, outcome of the Supreme Court's decision in case of
Your Lordship. SLP C number 3577 2015. Item 54.
no, not here.
55. 55 one, we have Mr. S.K. Savangi, one week after, I think. 1 week after.
Why? There. As requested on behalf of the petitioner, list this matter on 1 week. Let me see the order first. No content. The petitioner has alleged disobedience of this court's order dated 39/2014. Just a minute. Passed in WPC number CRLMP. Passed in CRLMP number 99/2014. Earlier writ petition was called CRLMP. Of 50% of it.
I may be pardoned, your lordship, in item 55. I may be pardoned, my lord. In item 55, I appeal for the petitioner.
Please wait.
A long time.
Please wait.
My lord.
When the court is seeing your item is 55.
My lord.
Is your item 55?
Yes, my lord.
And 55 has been called. Which item is called? Yes, what is your submission?
I thought it is 55, your lordship.
Yes, what is your submission?
My lord, I have not taken, I have to take instruction because long time has elapsed in the meantime after 2019.
What reply? There is no direction. What direction is there? What is the direction which has been disobeyed?
Direction is to allow me to have a separate electric connection.
No, there is no such direction.
There the contemptor single bench order your lordship will look at.
Yes, I am seeing that.
Last paragraph. And writ appeal has been dismissed. Honorable Supreme Court has dismissed their appeal, SLP. So I have to, if lordship permits, let it call next week. I will
file
instruction actually whether electricity.
All right.
My lord.
Though we are satisfied that no case of intentional disobedience of this court's order is made out, and senior counsel appearing on behalf of the petitioner has insisted for adjournment to address the spot on seeking instruction from the petitioner. First off, place this matter on 1 week. First off, the court, it is made clear that if in case the court is satisfied that that no case of contempt of court is made out, the court will consider imposing exemplary cost on the petitioner.
Immediate copy of the content. Immediate copy of the content.
Contempt petition, we will see. He has not given you contempt petition.
I am unable to.
You have not given.
Notice was issued, your lordship.
Alright.
No, notice was issued in
Alright,
2019.
Don't give.
I'll serve a copy, but it was
Please
issued
don't
in
give.
2019. My lord.
Item 57. 57 was compliance affidavit has been filed since 2/11/2016 now.
No appears compliance affidavit has been filed. Contempt proceeding is dropped.
Item 58.
Non appears.
Item 59.
No instructions. No instructions.
Item 60.
No instruction. No instruction.
62.
Non appears.
Item 63. This 63 was so-called has been filed, we have complied governor.
No one appears. Compliance affidavit has been filed. Contempt proceeding dropped.
Item 64.
Non appears.
65.
In order to release the petition was nominated, for which the contempt was filed. Thereafter, of course, the petition has been disposed of, but there is an observation kindly the advance of the petition order. 23 D 2017, passed in the record number 17/18/6 of 2013. And just placing it.
No, but how contempt petition? It has become infructuous.
After receiving the order of the interim order, they publish the record of rights. Even after receipt of the order, admitting that the order is there. That is why the contempt application was filed during pending of the writ petition. Thereafter, of course, the writ petition has been disposed of. There is an order in the writ petition.
2015 matter.
I have a glance at that order. I will apply for that. I have a glance at order dated 22/3/2017. Asked me the writ petition.
The petition was dismissed.
The petition was disposed of. That thing reverted to the petitioner to move to the section 15.
The writ petition stands dismissed. And the liberty was given to him to challenge that record of right in the appropriate forum.
We have a glance at the order that fourth.
See, learned single judge could have taken note of this fact and could have proceeded against that.
Yes, he has taken note of. And London single judge has taken note of that fact that some contempt application is pending, and that is to be taken up after even after disposal of the writ petition.
All right.
I'm just placing that first.
All right. Item number
65.
You are showing a switch order.
Order dated 22/3/2017.
It is dismissal order of the writ petition.
Where is that? Next. All right.
17. The record is available. On board.
One second.
Yes, which order?
Order dated number 7, 22/2017. Considering the rival contempt.
Mister, just keep in mind also the fact that even if there has been violation, the court may decline to proceed.
Yes, I cannot stop on the way of this court. But still, why I submit.
Decline because there are two different things. If you have a right, the court has a duty to enforce that.
Yes.
But if in such matters, in contempt matters, it is purely the discretion of the court whether to proceed or not.
I don't.
Therefore, that 9-year-old, more than this thing. 9-year-old matter.
Even after receiving the order also, the assistant sergeant officer and the tahsildar, they audited the same and published the record of right in the name of the state. That is why otherwise
The reports is still pending. The compliance of this sort of 15 application is still pending. But
Then
Just disposing of the present contempt application.
take note of my submission that
Uh, the present contempt application has been filed for disobedience of an interim order passed by this court in WPC number 17886 of 2013. Stop. 13, which was filed by the petitioner. Stop. This is not in dispute that the writ petition has been discussed. Stop. And counsel appearing on behalf of the petitioner has however argued that the reports of rights have been published despite the interim order passed by this court, and therefore a deliberate disobedience of this court's order is allowed. Stop. Based on submissions advanced at the bar, it has emerged that a proceeding under section 15B of Orissa Survey and Settlement Act, so and so is pending. So stop. And counsel appearing on behalf of the petitioner has vehemently argued that dismissal of the writ petition and pendency of the proceeding under the so and so act shall not absolve the contender from liability of contempt. So next. I am of the view that the present contempt petition has remained pending since 2015, and the writ petition in which the interim order has been passed has finally been dismissed. So, in such view of the matter, I am not inclined to proceed any further in this case. The contempt proceeding is wrong.
In 66.
and the compliance affidavit has been filed by the collector Kendra.
Compliance affidavit, no one appears, compliance affidavit. Yes,
Item 68.
no one appears,
69.
no one appears. 69, you are there.
Yes,
What has it not been complied with?
yes, my lord. Was filed the show cause. And the show cause is on the time, and also I filed the additional affidavit.
What is the order?
Supporting the documents.
Let me see, what is the order?
Order dated 19 to 2015. 19 to 2015,
Where?
this order had passed. But
Where is the order? Where is the order of the court which has been?
that let the appropriate decision to be taken matter in accordance with law after giving opportunity of hearing to the petitioner within a period of 2 months from the date of the communication of the order. And also the petitioner is directed to serve a copy of the order.
Sir, what are you reading?
Because my amendment.
आप क्या पढ़ रहे हैं? क्या पढ़ते हैं वो? क्या है?
That amendment petition is pending.
Order of the High Court पढ़ो.
Yes, order of the High Court.
कहाँ है वो order?
That order that within 2 months of the passing of the order.
That is not annexed.
Well, I have written. In the first paragraph, I have mentioned that order. That paragraph number 2. As page 3.
Somebody, 757.
Yes, sir. Wait, I will 757. 757.
considering the limited nature of grievance of the petitioner. In the matter of amendment of bylaw.
Show the order passed by this court. Whether that is there on record or not.
No, this is passed by the order by the Supreme Court. At page 2, my lord. Page 2, paragraph 2.
Read paragraph 2.
Considering the limited grievance of the petitioner in the.
That order. Where is the order?
I have mentioned that portion of the.
Where have you
In the
mentioned?
contempt petition, my lord.
Where is the contempt petition?
So, in the context of
Number 2, page number 2.
Paragraph 2,
paragraph 2,
What is that?
order dated 19th February.
19/2/2015.
Your application for to consider your application for amendment of bylaws is pending.
My lord, what has happened? His application was considered by the IGR after getting reports from the subordinate authorities. Now, and compliance affidavit has been filed. Now he has filed a further affidavit that there has been change because there is some controversy between two groups of the.
That you do.
That you can challenge in the civil suit because it is a private society.
But the order has not complied, my lord.
It is compliant.
But
The,
the complaint letter may be solved.
the petitioner has raised disobedience of an order of this court dated 19/2015, whereby the Inspector General of Registrar Orissa Cuttack was directed to consider the petitioner's application for amendment of the bylaws pending at the instance of the petitioner. So, compliance affidavit has been filed, from which it appears that the order of this court has been complied with, in as much as the petitioner's application has been considered. So, when counsel for the petitioner has attempted to submit from the submissions advanced at the bar, it appears that further disputes has arisen in relation to the society in question. So, in the court's opinion, no deliberate disobedience of this court's order is allowed. The contempt proceeding is dropped. Yes.
Item 70.
Page number 8 of the contempt application. That is the order I have composed. The order of this honorable court has been violated. The so-called reply filed by the contender. Let's say kindly see page 4.
So that matter is still pending.
No.
WPC is still pending.
WPC.
WPC is pending loss.
No, let me-
WPC 10892 of 2000 is still pending.
Still pending loss.
Why?
Yes, it has not been listed for disposal.
Why? 2024 matters are being listed.
No, because registry is difficulty to get the matter listed because there is no provision after the matter reach its in the complication of its formalities can be automatically listed. There is no such provision in the registry. We have to make application for listing and thereafter matter comes for listing. Therefore,
The petitioner has alleged disobedience of this court's order dated 9/6. Disobedience of an interim order of status quo dated 19/6/2015. Who has the building? What has happened to the building?
so now he has admitted, we'll also kindly see page 4.
What has happened to the building? Forget what has been listed.
So now at that stage, they have demolished portion of the building And in that stage, it is there.
When?
Admitted, you'll also kindly, therefore, my humble prayer, you'll also kindly see page 4, paragraph 7. There he has admitted that, with your also permission, I am reading out. It is pertinent to mention here that the suit land of the petitioner khata number so and so, plot number so and so, area so and so, decimals of Mauja Ostaranga with building structure standing thereon has not been demolished. Rather, only asbestos sheet covering PW road has been demolished. In spite of a lot. Rather, only asbestos sheets covering to PWD road has been removed. So, some of my building has been they have demolished.
No, sorry.
You are please interrupt.
The said order reads as under for status quo as on date with regard to the building situated over plot number 2291, khata number 1311/115, area acre 0.03 decimal of Moja Astaranga shall be maintained till next date. Stop. An affidavit has been filed. So-called reply has been filed on behalf of the opposite party, from which it transpires that wherein it has been asserted that the building of the petitioner has not been touched and only such part of the asbestos sheet which was covering the PWD road has been removed. Stop. In the court's opinion, in such view of the matter, in court's opinion, no deliberate violation of this court's order is made out. Contempt application stands disposed of. Writ petition only dismissed.
Item 71.
Non appears.
Item 72.
My lord, I beg your lordship's pardon, my lord. I'm appearing through VC in item 72 for the first sub-item, my lord. That is contempt number 905 of 2015, my lord. So 2015 matter, the writ application was disposed of.
My lord.
4/5/2015, my lord. The lordship may kindly see that order just for a moment. It's a very reasoned and speaking order which is.
You are appearing in 75.
72.
My lord,
72, my lord. 72. Sub-item 1. That is contempt number 905 of 2015. The lordship may kindly see the order, my lord.
72.
72 is, my lord, 72. My lord, I am there also. My lord, two items are there. My lord, I am in the first item. My lord, in that case, your lordship was pleased to direct the authorities to give me appointment within a month from the date of communication of the order. They filed a writ appeal before this honorable court. Writ appeal was dismissed. They preferred SLP before the honorable Supreme Court that has been dismissed on 18/3/2024.
That stay order is there with me, but what my learned sister is saying that this SLP has been dismissed. The lordship may grant me some time to take instruction. If it is dismissed, then the follow-up action will be taken.
They are handicapped person.
And that final order is not.
My lord, that SLP has been dismissed, but the interim order which my learned senior is saying is that has also been dismissed. That is observed in the SLP order, my lord. Your lordship may kindly see.
Maybe I don't
That
dispute.
interim order which was holding the place, your lordship may kindly see. This is a 2015 matter, my lord.
Contempt list this matter on 2 weeks. So as to enable seek instructions
My lord,
and file compliance affidavit. Yes.
my lord, see the order.
My lord,
Yes, the Supreme Courts. No, they will do it.
my lord,
I want to comply with the order now.
Yes, that will be, my lord.
I may be permitted to take a copy of the.
Give him
My lord, 2 weeks time.
2 weeks.
Item 73.
Sub-item 1, my lord, the petitioner has passed away. Meanwhile, we have filed an IE for substitution.
Do whatever you want to do.
Item
Your lordship
70.
may allow the IE will file a-
My lord, item 72 not pressed, my lord. I am for opposite parties.
Item 74.
No, no, here.
75,
On appeal.
76,
76 months and for the opposite party must subsequently included as a party, Blue National Development Authority. Must I pretty much taken up next week so that I will deal those instructions that
Whether the order has been complied with or not.
order is by what I found that the order has not been complied with. The order has been complied with because there is a direction to the chief secretary to dispose of the representation for allotment that chief secretary has already disposed it of. Subsequently, there is an observation that you exit that encroachment and give that land to him. That is the order of the chief secretary. And thereafter, my learned friend has come on contempt. In contempt, honorable court, the last order, honorable court directed that BDA should be made a party. So that BDA can exit that and do the observation, BDA can exit that and can hand over the position. But in the meanwhile, what happened is the BDA power has been taken away and it will be given to municipal municipal application. We requested the corporation.
May I request one thing to your, may I request one thing to your lords? Because the chief secretary is a party to this case and admittedly he has complied his part of the, so your lordship may direct deletion of.
No, not in piecemeal, because the chief secretary, the direction was of the chief secretary.
He has
Secretary has passed the order.
Yes.
And what remains?
Right now, order has not yet been complied with. That possession has not been.
Whose order?
My lord, order of this honorable.
Was the order, where is the order of the decision?
This honorable court, my lord. That is
26.
Your lordship may post it to next week.
No, let me see.
page 3, order dated 23/2/2015.
Annexure?
Under annexure 1, page
Yes.
8 of my contempt application.
Yes. So the order is in complied with.
No, your lordship, secretary has completed number. Pending grant, kind of grant to page 9 of reply of chief secretary.
I will not see the reply. I will see the order. Come to the order. Which part of the order has been valid? Invalid.
That is the last part, your lordship.
Yeah.
A final decision is required in accordance with law, keeping in mind the decision for allotment by the annexure 1 and 2 as well as the decision of allotment of alternative law.
That has been taken.
No, they have not allotted.
Allotted, there was the direction to take a decision. That decision has been taken.
Questions for annexure 1 and 2. Annexure 1 and 2, we have got allotment. And kind of annexure 1.
So therefore, an order has been passed in your favor.
Yes.
By the chief secretary.
Yes.
So the order is complete. The compliance of the order is complete.
Chief secretary has already replied that in pursuant to the order of this honorable High Court dated 23/2015, passed in the obligation of so and so, it is ordered that final eviction be carried out by the vice.
So there was no direction to comply with the order of the chief secretary.
Exactly.
Chief secretary.
All right.
But
By the order of this court dated 23/2015, the chief secretary was directed to look into the petitioner's grievance as regards allotment of plot by annexure 1 and annexure 2 of the read petition, as well as a decision on allotment of an alternate plot. Stop. This is not in dispute that the chief secretary has taken a decision. Stop. The petitioner is alleging violation of the said order of this court. So there is no dispute that the chief secretary, in compliance of this court's order, has taken a decision. So, learned counsel for the petitioner, however, has submitted that the authorities are not acting upon the decision of the chief secretary. Stop. There was no such direction passed by this court, which can be said to have been violated. Stop. In the court's opinion, no case of willful disobedience of this court's order is allowed, the contempt application is accordingly dropped. So the petitioner shall be at liberty to pursue his remedy before appropriate authority of public forum. This regard.
4/1/2024 for an amendment.
Yes,
For a movement, your lord.
yes, yes, yes.
4/1/2024.
Yes.
Your this honorable court has specifically directed that the BDS will be implemented party and BDO will implement the order of this.
That order is beyond jurisdiction.
But that order has been passed by.
That order is beyond jurisdiction and that order is not final. Final order has been passed. All right. So the what is not there in the original order cannot be made in an order in a proceeding under contempt jurisdiction. All right. That could not have been done. Yes.
Item 77.
That order is already complied. We have informed the petitioner, the executive engineer by letter number 2993 that is 27/6/15. I will give a copy to my connect.
On behalf of Mr. Umesh Chandra Mahanti, I am approving with the petitioner, my lordship. On behalf of Mr. Umesh Chandra Mahanti, I am approving for the petitioner.
Petitioner, what is your submission?
Upload.
On science specialist. What is your submission? My two numbers.
77.
Order is complied.
Complied with. Complied with.
Item 78.
Non appear.
Item 78.
28.
On 78, I am appearing for on behalf of Mr. Chana for the contempt of.
No representation. Both the contempt proceedings stand dropped.
Item 79.
No one appears.
Item 80.
No one appears.
82. 83.
Means automatically no instruction.
Item 84. Item number 85. 86.
Lordship, item 86, order has already been complied.
86, in this case, university sought for a permission from the government to regularize matters. Look at us, in the 17, they have not received anything till date. Your lordship, in this case, may grant me 2 weeks' time to ascertain if the university has received any letter for permission of the regularization. My lordship can say if the permission is granted, if not, my lord, may grant me 2 weeks' time, I will ascertain it.
Order is complied.
86.
Not complied.
What is the order?
No. University petitioner.
It is.
Liberty, we can. Liberty.
It is considered better.
Yes. The order has been complied with.
Yes, yes, your lordship.
Complied with.
The order has been.
Nothing to say.
Item 87.
All of Compliance.
Complied with
89.
Direction was not to substitute construction work matters. But the opposite party consumer, I have a glance to page 3 of my petition matters. Order. Order dated 3/9/2015 matter. Specific direction was there not to prosecute construction work matter. But kindly have a glance to page 7.
where is the order?
Order is at page 3 of my petition. I have typed the order matter.
So your writ petition is pending.
Matter.
Huh?
Kindly have a glance to.
Petition is pending.
No, matter.
Is it an interim order?
Yes, matter.
What happened in the writ? Then why contempt proceedings should remain pending?
Matter, kindly have a glance to page 12 and 13, matter. The photographs. Highlighting that direction, they have completed the work, matter.
What happened in the writ petition?
It is pending now, matter.
WPC 15238 of 2020.
Pending, matter.
Let's just get along with WPC number 15238 of 2015. We just said it's still pending.
Item 90.
This one.
91.
There's a kindly page 16, the operative portion of the order. Page 16, last but one para. In page 16. In view of the reasons mentioned herein above, the impugned order dated 21/10/2002 is hereby quashed. That my reversion order. They have filed the show cause. In page 40, they have stated we have given complied the order, stating we have reinstated you from the date of High Court's order, not from the date of reversion. Page 40, they have stated.
So where is the direction?
Matter.
Where is the direction that you should?
Direction is reversion order is quashed. Is auto, my lord. I am entitled to get the benefit from the date of reversion, my lord. But they have stated in page 40
by order of this court dated 13/7/2015, an order passed against the petitioner by Registrar, Indian Institute of Mass Communication, dated 21/10/2022, reverting the petitioner from the post of assistant to the post of LDC/typist, came to be set aside by an order of this court. An order of this court dated 13/7/2015. It is not in dispute that in the light of this court's order, the order of in the light of this court's order, the order of reversion dated 21/10/2002 has been recalled. Stop. Excellent. Counsel appearing on behalf of the petitioner, however, contends that since the order dated 21/10/2002 was quashed, the petitioner was entitled for all consequential benefits, including the salary, difference of salary from the date of passing of the order of reversal. So stop. He submits that the order of reversal has been recalled with effect from which date?
On the date of High Court Order 13/7/2015.
Effect
Page 40.
13/7/2015. Stop. Next, I do not notice any such direction that such specific direction meant by this court that the petitioner shall be entitled to consequential benefits also from the date when the impugned order, when the said order dated 21/10/2002 was passed. So stop. In such view of the matter, I do not intend to proceed in the present contempt proceeding. So stop. It is, however, observed that the petitioner shall be at liberty to approach appropriate authority oblique forum, raising his claim as regards consequences of washing off the order of reversal dated 21/10/2002 passed by this court. This application stands disposed of accordingly.
Okay. 92, 93.
What instruction I have received which is available that he has already disposed of the encroachment case as directed by the order. After hearing the petitioner.
Complied with the
Item 94.
Okay.
Item 95.
I pray my lord, let it be taken after recess. Wrong. There are two contempt petitions. One was of 2015. That was disposed of, that could not be disposed of. So 2016 contempt was filed. Inadvertently, 2015 contempt file has come. I called for the file maybe after recess or any other.
Next week.
Item 96.
Minus are kept it after recess.
Next week.
96, no instruction.
No instruction.
Item 97.
Workshop, I'm standing for on behalf of Assembly Sol. Item number 97 and 98, there's no instruction.
No instruction.
Item 99.
On behalf of Sri Vimbi sir, my lord, order has already been complied.
Complied with.
Item 100.
Let me. I have taken instruction, the violation still continues. Your lordship will see the direction that was passed.
Where is the order?
The order is at page 11, your lordship.
Page 11. This is 216 of 2016.
This one.
Is not there.
My lord,
Where is that?
and the scanning might not have been done, my lord. The physical file must be having this page 11. Page 11, it commences, my lord, from page 9.
Page 9 is your work.
I'm sorry if there is disparity.
No question of disparity. There is nothing on report. The file of fresh contempt application.
Your lordship,
Contempt application has been filed alleging disobedience of an order dated 17/10/2014 passed in WPC number 17988 of 2014. stop. Neither the said order of this court is not there on record. Stop. Since the matter is pending since 2016, I am not inclined to proceed in the present contempt matter, which stands disposed of accordingly. The petitioners shall be at liberty to take recourse to such provision of law as may be permissible to him.
Obliged. Item 101.
Madam, I'm for opposite. 100 item opposite.
Lordship, item 101 order has been completed.
102.
Why? Yes. No. Very difficult to get the cases list. All right, next week.
Item 104.
Appears.
105.
My lord, no cause of action survives.
Infructuous.
106. No, institution mirror.
No instructions.
No. 107.
No appears.
Item 108.
No appears.
109.
No appears.
Item 110.
No appears.
Item 111.
No appears.
Item 112.
Your order has been complied with, your lordship.
113.
No appears.
Item 114.
114, annexure 1 is the honorable court's order. Annexure 1. That is order dated 21/9/2015. Till today, no comply.
So considering the innocuous prayer made, this court directs Tahsildar to issue ROR.
No, that land is with village first area, my lord. We have filed a miscase for modification of that order. That miscase is pending, my lord. In the writ petition, my lord.
This is an innocuous order that issue ROR in favor of the petitioner.
Because already mutation order has been passed.
So mutation order is
Read for issuance of ROR.
ROR, but this is what he has already filed an application. The following is the order passed by this court, violation of which has been alleged in the past. Following is the operative person of the order dated 21/9/2015, passed by this court, violation of which has been released in the present contempt application, followed as last paragraph considering. Then counsel appearing on behalf of the contemptors has submitted that miscellaneous case has been filed seeking modification of the order since the order dated 21/9/2015, since the land in question has been found to be forest area.
My lord, village first. Village first.
Found to be in the nature of village forest. So, in such view of the matter, no deliberate disobedience of this court's order is made out. Also, miscellaneous case, where is that?
Now, miscase 7763 of 2016, my lord. In the writ petition we have filed.
We pursue that.
My lord.
Make a mention. Let WPC, let Miss case number so and so be listed before appropriate bench. After all, any orders from the Chief Justice.
Sub item 30 minus. Sub item 302 contempt, sir.
Same.
Item 115,
None appears.
116,
Same order.
117,
17 order has been complied.
Complied with.
118,
189 for the housing board, my lord. So for that re-petition or judgment of the re-petition members, we filed a review petition, even a review petition number 246 of 2017. But the contempt appeared and filed so called the pending consideration of the Honorable High Court last listed on 20th September 2019.
It is stated by the learned counsel. Who is for the petitioner? Let this application be listed along with RV WPET number 246 of 2017 on next Friday.
item 119,
So-called I have already filed. I am appearing for Chief Administrator Sri Jagannath Temple. Filed my so-called I have already filed.
Whether it complied with or not.
No, the direction was to dispose of the appeal pending, which is supposed to be disposed of by the appeal subcommittee. It is constituted under section 24(3) of Sri Jagannath Temple Act. But the Chief Administrator is not a party to that committee. So that time committee was not there. Since I am for Chief Administrator, he has not included appeal committee as a party here. So your lordship may, in the meantime, I don't have an instruction whether appeal has been disposed of or not, because it has been disposed of by some other body. So I have to take instruction whether appeal is still pending or not.
Appeal is pending.
My instruction is the appeal is pending.
No, your appeal
He is not made.
No, the direction was to the chief.
Direction was to the chief.
Chief, he cannot do anything.
My
And whether the appeal is pending or not, you tell us. You tell the court.
My lord, before 2 months, my client was contacting me that appeal is pending. So in the meantime.
2 months. All right.
I'll take
2 weeks. As jointly requested on behalf of the parties, so as to obtain instructions from their respective clients as to whether the appeal which was directed to be disposed of has been disposed of or not.
Yes.
item 120,
120 complied, madam.
Complied.
121,
On appeal.
122, 123,
123, no instruction.
No instruction.
item 124,
On 24 minutes, I am for the university, where the direction to dispose of the representation has been employed with members that has been disposed of.
Complied.
On 11/12/2017.
Complied with as stated by and counsel representing the contenders. There is no representation on behalf of the petitioner. Contempt proceeding.
125,
No instructions.
126, item 127,
127, your lordship. As far as I have the instruction that the order has not been complied. It was a simple direction to consider my representation and pass an order. Has not been.
Yes.
Your Lordship, his license has already been renewed, Your Lordship, on 28/7/2016, Your Lordship.
Lordship, then. Lordship, contempt.
item 128,
No instruction.
No instructions.
129,
No appears.
item 130, 131,
No appears.
Item 133.
That I am appealing for the university, the order already complied since 28 September 2016.
Comply with, compliance, contempt, representation, dispose of. Property. Yes.
134.
Order has been complied, sir.
Comply with.
135. 136.
136, madam, the order has not been complied, madam. The direction, the order has been quoted in the in the content petition, that is at page number 2, my lord. Paragraph 2.
Your Lordship, we were served a copy yesterday, Your Lordship. Your Lordship may see the notion where, as per report of stamp reporter, that no order dated 1/9/2015 passed in WPC number 23729/2015 mentioned in the prayer portion. It was on a defect, Your Lordship. We received a copy yesterday only. 2 weeks time may be given.
I humbly submitted that is a typological error 1/9/2015, but in the petition portion, the order has been correctly mentioned. It's order dated 21st January 2016. That is the only typological.
Posted on behalf of the contempt.
I may be permitted to correct the order date in the prayer portion, madam. Because that's the only typological error in the prayer portion, madam.
Requested on behalf of the contempt. Let this matter on 2 weeks. What's wrong? 2 weeks since, according to her, she has received a copy of the contempt petition recently,
Yes, Your Lordship, yesterday only, Your Lordship.
only yesterday. Yes. 2 weeks.
Item 137. May I please proceed?
That on behalf of Mrs. Jena, the matter has become infructuous.
138.
My lord, that is, they filed an affidavit stating that they have complied. But liberty may be given, whatever the views are there, I can, with a liberty, my lord.
Liberty to raise his grievance before appropriate forum relating to any other entitlement. Any other entitlement. In accordance with law. Yes.
139.
Not pressed, my lord. Not pressed.
141.
Order 8/4/2016 are not complied. In spite of an honorable court order, the contempt number 1 had not allowed to sit in the trade test examination. They are not allowed to sit in the trade test examination, though allowed to the juniors and others. Order 8/4/2016.
In the order.
An intermediate directed that the opposite party shall allow the petitioner to appear in the trade test examination.
Where is the order?
I have annexed one in the content fiction. Last page of the brief.
Where is the order? Annexure 1.
Yes.
And what happened to the writ petition?
Writ petition depending. Writ petition depending.
This case along with WPC number 19754 of 2015. Yes.
140.
Four weeks couple for assigned bench. Yes.
142.
On appeal.
144.
No.
145.
145 minutes and for the contempt. That contempt petition become infructuous.
How?
The order of the authority.
Why are you Ashraf, no.
Sorry, my lord.
His permission.
Yes,
You
sir.
may say no.
I have to submit my case for that reason.
The order of the authority.
This is what he is saying, that the order has been complied with. Let me see the order. This is item number
145. Your lordship, the order has been quoted in page 3 of my petition, my lord, contempt petition.
Just a minute. This is an interim order.
Yes, your lordship.
The writ petition is pending.
Yes, your lordship.
So let that be heard.
Order has been withdrawn, out of which this interim, its content or petition that is filed, my lord, that order of the authority, which has given rise for all of the content, that has been withdrawn. That is why it's become.
Then it is rule. So I may request my learned friend to
Give him
145, 146.
the contempt application after having heard submissions at the bar. It appears that the writ application has become infructuous. Stop. Then writ petition also must have become infructuous.
No, my lord.
It's pending.
Writ
No,
petition-
because you have recalled the order,
No,
therefore the writ petition is
my lord, that's only an interim order.
all right.
This is still heard.
146,
Say.
147,
Not press, my lord. 147 not press, my lord.
Not pressed.
148,
48 members complied. I'm for the petition.
149,
Okay.
item 150,
Not press, your lordship.
151,
My lord, I will kindly allow 2 weeks time to take necessary instruction from the petitioner regarding the compliance with the order.
This is of 2016. Since there were no instructions, then no instructions.
In fact, in the meantime, I admit my.
Do you have, is there any limitation for lodging of criminal cases in this thing, petty matters?
Actually, the.
Now forget contempt. Whether in criminal cases, there is any limitation under the CRPC
Yes,
or taking a cognizance.
To criminal cases, there is limitations. So state CRPC, old CRPC.
Accordingly, in the contempt matters also, there is some limitation prescribed under the Limitations Act. We ignore that. We ignore for the reason that this is an order of the High Court. It should be respected.
Yes, my lord. Yes, my lord.
Now, since the order is 2016.
It was in my favor. The order was in my favor. It is up to the my learned friend.
No, it is not up to your learned friend, up to your client. Had he been in some trouble, he would have.
I have filed contempt and regarding the compliance, actually.
Since you have no instruction, you cannot pursue.
No counter compliance.
No counter, no instruction.
No counter has been filed by the state.
Forget, why are you blaming the state?
My lord, I am the petitioner.
You are the petitioner, but where is the petitioner?
I am the petitioner.
When did you contact him last? Or when did the petitioner contact you last?
Actually, her nephew contacted me. I just last night I got the information that in the meantime he died. For that reason.
They are not willing. They are not willing to pursue.
Yes, my lord. Just 2 weeks time I can. Otherwise, I may press the
instructions.
Order. The order is Annex 1.
All right.
Annex 1.
No, that's 152.
Next item 150.
He is
151. Sorry.
Annex 1, it has not been complied.
And if it is
found regarding this things I do, my husband died. Thereafter, I am to get family pension and other benefits and the consequential service benefits. There was series of litigations. Ultimately, this contempt, that is 1259 of 2016, and no compliance has been made by the state. That is Annexure 1, page number 62.
This is coming for the first time also, Your Lordship. This was never.
All these matters are coming for the first time. But you should have been ready with the status 2 p.m.
And 152.
My Lord, discuss.
Make the job. But it appears the order has been complied with, my lord. Item 153 obliges. In my Sukura land, the government has been constructed the honorary center. Therefore, I refer this on Equal and unequal pastor. And therefore, that will not construction stage. Completed that is today.
No disobedience.
Huh?
No disobedience of this court function.
After disobedience, that construction was complete, but we have not handed over to honorary center.
What was the order? What was the order?
I have not do my.
All right. See from there.
Copy has also not been served on us.
Item number
153. The grievance of the petition is that the opposed by the order dated on 27/9/2016 manner. In repetition, the grievance of the petition is that the opposite parties has.
So serve a copy. Serve a copy on her.
That's why I will collect the copy and serve my.
1 week. As requested on behalf of the petitioner.
Item 154.
I have no instruction, Your Lordship.
No instructions.
155.
No. On the period.
Already filed the compliance certificate.
Compliance affidavit has been. On behalf of the contemptuous, proceeding.
Item 156.
My lord, on behalf of Mr. Rai, non-compliance of simple order of dispose of representation.
Dispensation dispose of.
No, my lord. Non-compliance of order of simple direction with regard to dispose of representation that is pending since 2016. Page 7 order.
Who is the for the
After lunch, I'll take this.
2 p.m.
156 was over. Item 157.
157, my lord, order dated 1/12/2015 has not been complied. Here, my lord, I'm reading the authority person, my lord.
Where the order?
Order dated 1/12/2015, my lord.
Where is it?
1.
Where is that?
That is at Annexure 1, my lord. The judgment 1/12/2015.
Yes, page 26 and page 27. That is the only direction.
No, page 20, my lord. Direction was page 20.
No, paragraph.
It starts from page 10 and operative is page 20, my lord. So far as the point number 2 is concerned, the prayer for announced DA.
State.
A review has been filed. May I pray that review may come along with a review has been filed that review.
Review.
Yes. And I have filed an so-called affidavit that I have stated that review,
No number, nothing has been given that.
266,
The
the review number is 266 of 2016.
266.
My lord.
It is stated by Mr. AGA and counsel representing the contemners that a review application has been filed seeking review of the order dated
That is 1/12/2015.
1/12/2015 passed in WPC number
WPC number 18079 of 2012 and batch of cases.
violation of which has been alleged in the present application. Stop this matter on 2 weeks with RVPET. So yes.
It will come along with the review after 2 weeks. It will come. The other 3 cases are also same. All the other 3 cases are also.
Yes.
158. Both the cases, no cause of action survives.
No cause of action survives. Proceeding stands stopped.
159, no instruction allowed. None. 160.
Lords, in fact, I am for the opposite party. The contempt is against a non-existent person. Your Lordship, I kindly see there is no person called ASR Agarwal. It's a company. ASR Private Limited is a company. He has filed it against a non-existent. So it should.
There is no representation on behalf of the petitioner and counsel for the contemptor is present. Application. Contempt proceeding is brought.
Item 161.
My lord, I may be allowed through VC. In this
Yes,
case, my
ma'am.
lord, the cause of action is still surviving, but the order of this honorable court in 16/12/2016 showing that contempt proceeding is accordingly disposed of. So I unable to say that whether your lordship will take it or not.
If it has been disposed of, then what can be done?
16/12/2016 is saying it has been disposed of.
Then
But the cause of action is still surviving. The lordship can initiate so much of contempt proceeding also, my lord, in this case, because the poor petitioners are suffering by in this case by the writ of appeal is pending. Subsequently, another writ has been disposed of.
No, but what is the item?
Further,
161.
Disposed of matter recovered.
That is it.
This is not disposed of.
so I need the next week it may be taken up so that I can set the lordship then how the matter is next week it may be taken up. Physically, I will move.
Yes.
They have solved
For your
them.
lordship.
Copy of the contemplation was solved on 18th. I'll take instruction what has happened in the meantime.
Yes.
Next week, your lordship.
No, 2 p.m.
2 p.m. madam.
2 p.m. when the chief secretary will be, chief secretary is going to join the online proceedings.
Madam.
Okay, my lord. I will appear physically.
162.
Obligation.
On appear.
163.
The order.
Item 165.
Just giving a short list of dates. In paragraph 3, page 2, the first interim order was 165. And thereafter, the final order is at paragraph 5, page 3.
Page 3 of the contempt petition.
Of the contempt petition, paragraph 3 at page 2. May I just place that order, 10/7/2012. The contempt petitioner, my lord, is Paradip Port Trust. It's a central government undertaking under the Major Port Trust Authorities Act. Now, interim order was granted on 10/7/2012.
Paragraph, where is the final order?
So in the interim order, it was mentioned that they will enjoy the plot subject to payment of the dues. And then the final order is at para 5, page 3. The petition is dismissed as withdrawn on the statement of Mr. T. Mishra, learned counsel for the petitioner, subject to the condition that the petitioner will pay the dues of the corporation for the period the petitioner has enjoyed the same. So the corporation is before your lordship. The interim order was there for that.
Corporation is alleging contempt.
Yes, because of this order. So they got an interim order, but for that period they have not paid the dues. The dues are roughly to the tune of 7 crores 88 lakhs. That
Who is for the contempt?
And for the contempt petition.
Who is for the contempt?
I'm there, Malad will also will see. This is the first of all, it's a crime by application and the similar order has been challenged, the contempt proceeding, Malad, this order has been passed. Please.
Who is he? Where is the contemptor? Where is the contemptor? Where is he?
Where is he? Well, container is, I'm from the container. Container is, so and I did, this is the order which has been passed in the batch of cases, and this is one of the cases where they filed a contempt application, and contempt application dismissed because it is all beyond 1 year.
I will consider this order in the presence of the contemptor. All right.
Contemptor given present law. Fix a date to that. Contempt, I'm depending on the contemptor.
The contemptor will have to be personally present.
Oh, now he's abroad ballot. He's abroad ballot.
He have to come.
He's abroad ballot.
He have to come. Otherwise, we will take action. The court will not leave him like that.
This very demand ballot has been challenged with interpretation. Honorable Court has granted stay, and they have also filed execution petition that execution proceeding was also been stayed by the Honorable Court in the proceeding. So these proceedings, the
petition is pending.
Petition as well as the execution petition also. They have also filed execution petition to implement this order of the Honorable High Court.
No.
And execution stay.
Sir, this contempt petition is pending or not? This petition was dismissed.
Sorry,
this petition was dismissed.
This petition, this another content, this similar order has been passed in batch of cases. Another content application in the same case,
same order I may pass, I may not pass.
In this case also, what has happened? We have challenged with the weight of demand. There also been legal execution petition. The execution petition has been
I'm adjourning the matter for the next week. You seek instructions from your client. When will he come? All right. And if he may not return thereafter.
That
was an undertaking given by him that has to. So it is better if he pays that. Otherwise, you inquire from him.
Well, they have raised the demand, and demand has been said, and also this content also, I understand the content also not maintainable because of that.
Seek instructions from your client. Seek your constructions. You can tell him the court's observations. But he must be watching. This is online. He can watch. The next proceeding he can watch. Next proceeding he can watch. You can see the court's observations also. The court observation as on date is that the court may follow what has been laid down. The court may defer. The court may refer the matter to a larger bench. The court may direct him to be personally present. If he personally present, if he appears in court, the court may not allow him to return.
That
undertaking, what stay has been granted, Mr.
they raise the demand and the demand has been stayed and execution, I am just Indian. Execution petition also, they have filed execution petition implementation of this order, which has been stayed by the Honorable Court, and because we have challenged definitely the execution petition, that has also been stated also. Contempt is there.
And the High Court rules under Order 21, there is a procedure for executing the order. And execution was filed. They filed a Section 47 CPC application challenging the maintainability of the execution before the registrar. The registrars of the High Court take up execution matters. That petition for maintainability of my learned senior was rejected. Against that, they have preferred a CMP. That CMP is pending. So we are trying our best to recover these dues. As on date, these dues remain
dues also, we have challenged the dues also in separate petition, that has also been stated by the Honorable Court, because this is the dues not maintainable, that's why I have given the copy of the order. Copy of the order.
All right. So what is the effect of that observation? No. Your undertaking.
The demand is contrary to the order, that is the why we have challenged that this order has not been. There cannot be any demand, there cannot be any demand like this, that is the reason why this Honorable Court has entertained the application.
According to you, what is the demand?
There is no demand at all. So election can
There are all
and complex the order because we have vacated the premises and we have deposited the amount, whatever bill agent, we have deposited the amount.
So what amount you have deposited?
Sorry,
how much amount you have deposited?
Amount around 30 lakhs, around 30 lakhs.
30 lakhs.
So 30 lakhs.
After this order, 25/4/2014, you have deposited.
Before that.
So if before that you had deposited, then why did you make this?
The demand is not in academic.
Please come to paragraph 5 of the contempt petition. It says, see Misra learned counsel for the petitioner subject to condition that the petitioner will pay the dues of the corporation. So this was not in past, this was in future. All right, this is in future tense. It says it will pay. After 25/4/2014, did you pay any amount?
Well, the Lordship kindly see, they raise the demand, that raise demand, the amount we have to pay, they said that they don't accept that rate.
25/4/2014, did you pay 5 rupees?
No.
Then?
No, that's my understanding is that.
The instructions as requested on behalf of the court is on the prima facie review that deliberate that the contender has dishonored the undertaking given to this court on 25/4/2014, which has been recorded in the said order on 25/4/2014 in WPC number so and so. First off, learned counsel for the petitioner has relied on division bench decision of this court to contain that this contempt application is time barred and deserves to be dismissed on that ground. So we will consider the said submission on the next date. First off, place this case on next Friday. So in the meanwhile, you may seek instruction from your client, whether he is ready to pay or he is not ready. Or I must tell you that if any proceeding is pending and if that has to be decided, that shall also be decided. All right.
So all two proceedings are pending for that reason.
Everything, your contempt, CMP, everything. That's what
item number 327. If possible, taken at the last case, because petitioner is retired by 31st. And petitioner retired by 31st, your lordship passed the judgment directing to give him regular appointment. By a lordship's intervention, they have given him appointment, the temporary appointment of 6-7 as a temporary for 24 days only. So unless until you have taken up after retirement, no, nothing will get. So, at least you lordship, last before rising minor for that. Any instruction given further by 26. So the content is infructuous by 30. By government.
But I'll take instruction. 327, I have not seen. I'll
Take instruction, I'll take up the matter as special case on Tuesday. Correct.
Yes.
So I will notify the matter on Tuesday. If he comes on Tuesday to tell the court
Yes.
that the order has not been complied.
Apply.
327.
Passport matter item 34. Not in item 34, as a matter of fact, I found that this order has been complied with since 13/4/2015 by taking a decision in terms of lordship's order. And then he also has directed the.
So why this order was required to be passed today, the morning?
Morning, because I didn't have the, I made a.
Because you don't have the instruction.
Yes,
You
sir.
don't have the instruction? Why you don't have the instruction? Why, madam, why are they not having instructions?
Sir, from our side in 2015, this was complied with. And
This
a
was
copy- Yes, sir.
It was complied with, but there is a contempt petition pending. You were required to inform the council that the order has been complied with. Or even when now the situation is that we are dealing with 2014 matters in 2024. So at least the government council should be informed that these are the cases in which the orders have been complied with. Or in these contempt applications, this is the stand. So in 2024, they are saying that they don't have any instruction, and that was the reason why the court had to require personal attendance of the chief secretary.
Yes, sir. Sir, Chief Secretary is on an official tour today.
All right, that
That's
is
why
a
I am
different
there.
matter. That is a different matter. But
I know,
please
sir.
look into it. Please have some. Please frame some guidelines. Evolve some system, some scheme to ensure that there is proper communication between your departments and the state council.
Will do, sir. We will do
Otherwise,
that.
the old matters are unnecessarily pending.
Yes.
Without any purpose, you have complied with the order. The contender is saying he does not have any instruction. He says the order has not been complied with. Land Council does not have any instruction. And the court is struggling with the pendency of cases.
Yes, sir.
Evolve
So
some
we'll do
system.
that.
And please ensure that at least, please find out, please evolve some system so that you may have the information that in all such matters where the orders have been complied with, whether contempt petition has been filed or not, that information is made available to the state council, the Advocate General's office or the state council who are conducting the cases. Please do it.
We'll do that, sir. We'll do that.
And it is not very difficult here to do 2-3 things. One, where there is a direction that has to be implemented, that in many of the cases you must have implemented. There is no reason why will you not implement. But it's a clear case of communication gap between the government and pursuant to this court's order passed in the first half. The additional secretary, additional chief secretary, development commissioner, government of Odisha, has appeared online, in the absence of the chief secretary. First off, she has submitted that in this case, the order of this court has been complied with. Full stop. In such view of the matter, the present contempt proceeding stands dropped. Full stop. Next, the court, however, observes that it is expected of the state government, its departments and officials to ensure that there is due communication between them and the state council who represent the state of Odisha and its officials before this court about compliance of various orders passed by this court. The contempt proceeding stands dropped accordingly. Person attendance stands dispensed with.
But more than 3,000, 4,000 cases, decisions have been taken pursuant to lawsuits earlier indulgence. We give those laws, we have asked them to give those orders so that we can supply it and all those cases can be disposed.
You supply those orders so that such cases are listed.
Yes.
See, on priority basis, where the contempt matters are pending, the orders have been complied with, only such cases can be listed on one day for their disposal. Please ensure that something is done. Thank you. Thank you. And that is the reason why other cases were also adjourned to be taken up at 2:15. So there are other matters of 2016, 2000. What has happened in 2016?
Item 39. 2014 was item number 39. All has been already complied with.
39 complied with.
Item 56.
Yes, item number 56, I will talk to the CBN. If you see, try to get the filement, but she was, I was in the session note. Next week, last week, in the meantime, I will obtain positive instruction what has happened to you.
All right. Any other matter? 56. 56 का अलावा तो कोई नहीं ना है. All right. Thank you.
No, 1 minute. The matters.
Just a minute.
Item 151.
Just a minute.
151.
151 was my friend is there. I think there was some miscommunication. She thought that my friend thought that he was also taking.
All right.
Next week.
All right. Next week. All right. Next week.
156.
Next week.
156.
Other matters will come next week.
Well, 156 and 161.
156 and 161 will come next week.
Next.
Yes.
161 was passed over by your lordship.
Oh, why? 161 will come next week.
Item 166.
Non-compliance of order dated Highway 2016 under answer 1, my lord.
So it has not been complied with.
My lord.
What is the order?
On page 6, my lord.
Page?
Page 6. Under answer 1, my lord.
Disposal representation.
My lord.
This was passed in 2016.
My lord.
So when did you talk to your client? Where is your representation?
The answer 4 in the read petition, my lord.
How was this communicated?
My lord. Page 7, my lord, can you see? Page 7, commented to the Director of Higher Education.
How? How was that communicated? The writ petition is there before me.
My lord.
The writ petition is there before me. How was the representation communicated? Where is the question of disposal of representation which has not been communicated? Sorry, have you seen? Come to paragraph, page 14, 12, and 13 of your writ petition. The petitioner has alleged in the present contempt application disobedience of an order dated 5/8/2016, passed in WPC number 13571 of 2016. The writ petition was disposed of with a direction to the opposite party number 2 of the writ petition to dispose of the petitioner's representation, which was at annexure 4 to the writ application. First of all, next I have perused the records of the writ petition, and I find that there is no proof of filing of the said representation which was required to be disposed of before opposite party number 2. First off, in such view of the matter, and considering the fact that the contempt proceeding is pending since 2016, it stands dropped. Yes.
167.
No, no,
168.
Your Lordship. My lord, order of the Learning Tribunal dated 21/7/2017 has not yet been complied, my lord. The Lordship have a glance, page 5 of my contempt petition, my lord. So, running page 6, my lord, last paragraph. Considering the submission of Learning Counsel for the applicant, Learning Standing Counsel as the grievance of the applicant for regular appointment on completion of 6 years of service has not been denied and is pending active consideration response number 3. The OA is disposed of with the direction to respond number 1, 2, and 3 to take appropriate action for regulation of the services of the applicant and issue appointment order following.
Yes.
My lord, I've seen that there is a SOCA that was in that SOCA which was stated that a petition has been filed. Let's call this matter on Tuesday. What is the status? Perhaps this order has been challenged before this honorable. I'll collect that data. Let's call this matter on.
This order not challenged, my lord. This order has not yet been challenged before this court. I am confirming.
As requested on behalf of the estate, list this matter on 1 week.
169.
Sorry.
169.
This case has been rejected, my lord. In the meantime, that has been complied with.
168. So.
That has been complied with.
Which
by the order that 29/2/2024, its case has been rejected.
Give him a copy.
Yes, I have.
Well, they have served a copy upon me, my lord. There is no liberty by the tribunal to consider the case of the petitioner and pass appropriate order. There is a clear-cut direction I have read out before your lordship. But what they have taken, superseding the order of the tribunal, they have passed another order rejecting my regulation, my lord.
File your reply rules.
Yes, problem.
As requested on behalf of the petitioner, list this matter on 2 weeks.
Item 169.
Well, at 169, we are but the opposite parties. We have lost the case in Supreme Court. We are ready to comply. They require 3 months' time.
How much time?
3 months' time.
3 months. The court will not
Why
give.
not? Because
this pension process will be complete and entire thing will be regularized, my lord. Let's say, I leave to the court, my lord, let's see whatever time.
No, but when was the Supreme Court?
It is long back, in the January 2024,
24.
but ultimately, the 16/1/2024.
Let us suppose reply be filed on behalf of the contemners as to why contempt proceeding be not initiated against them, and they be not punished for deliberate disobedience of this court's order, violation of which has been alleged in the present contempt application. Place this matter on 8 weeks.
Oblige, man. Oblige.
Item 170. Non-compliance of order dated 3/2/2026. On that day, the Supreme Court directed to implement the recommendation of Inspector of School Lordship. Give minimum guarantee to the petitioner school Lordship. Till date, they have not taken any decision, Your Lordship, and the matter is pending, Your Lordship. Receive granting and matter, Your Lordship.
Well, there is a show cause has been filed. Some communications are there, Your Lordship. Call this matter also today. I'll obtain the instruction. There
It will come on next Friday.
Yes, ma'am. I will instruct,
but not next Friday.
Complaints order, my lord. I will come with the complaints
It will come on Friday, but henceforth, one senior officer of each and every department should be present in court. This is the order which I intend to pass.
Well,
or they will join online. As requested. 1 week.
172.
On appeal.
173.
My lord, can see page, running page 11. This was the order passed by the Supreme Court. In view of the aforesaid, last but one paragraph. In view of the aforesaid facts and circumstances, the opposite party state is directed to comply the order dated 2/6/2011, passed by the London State Education Tribunal in GI case number 77 of 2009 by the Annexure 1 within a period of 2 weeks from the date of communication of this order. This was not complied. Therefore, contempt number, case number 1823 of 2015 was filed. Your Lordship can see they have filed a show cause, and in the show cause also, they said that they are going to comply it, but they did not comply it, and ultimately, my lord, the order was passed in that contempt case at running page 28. The page 30 is the directions and the observation made by the Supreme Court. It is all, as a part of the order has been complied with, and with regard to the release of granting aid through though an amount of 24,12,788 has been sanctioned, the same has not been effectively disbursed till date. It is directed that necessary steps for disbursement of the same to the petitioner be taken as early as possible. And so far as the claim of the senior and selection grade scale up UGC scale up is concerned, this court grants 4 months time to consider and dispose of the said claim in accordance with the law. This has also not complied with, and this order has been this second contempt has been filed.
Yes, who is for the other thing?
That file is not with me, Your Lordship. But file is misplaced.
Which department?
Education department, higher education.
All right. The petitioner has alleged deliberate disobedience of this court's order.
Higher education. Other cell phone.
7/8/2015 passed in WPC number 15891 of 2014. And subsequent order dated 9/12/2016 passed in CONTC number 1823 of 2015 15. So stop. This is second contempt application alleging disobedience of the same order. So stop. The court takes serious view of the matter. So stop. Let. Who is this? Who is the director? Director education.
Director higher education.
Let the director higher education personally present in court on next Friday.
174.
No,
175.
No instructions.
176.
76 minus complied.
On appears complied with.
Opposite party number 5.
177.
On appears.
Item 179.
And for the opposite party, madam.
Yes.
Item 180.
180 minus the maximum purchase.
But yes.
Item 181.
No one appears.
182.
Compliance of order date. Non-compliance of order date is 16/5/2017. There is a
Whether order has been complied with or not?
It is not complied.
What is the order?
Order Lordship Annexure 1. The direction was issued to the lower court to provide certified copy. The till today is not supplied.
So you wanted the registrar of the civil court to get certified copy of an order?
Yeah, the case number, SO number 60, SO number, Lordship, SO number 56/1968. I want to the order because the childhood, my father is dead, I am contesting the case. My childhood, father is expired. He is contesting the case. Every land document in this case, every land document is, it is a vital judgment required.
Yes.
Well, your Lordship, the order that the read petition is disposed of directing operating partner to supply the document as per within 7 days of receiving certificate if there is no other legal impediment. A letter is received from the registered civil court on 21/9/2019. I'm supplying the
Standard.
Yes, it is there. They could not find such account. The petitioner alleges disobedience of this court's order dated 16/5/2017, passed in WPC number 8701 of 2017, whereby the Registrar Civil Court Bhubaneswar was asked to supply the documents as the petitioner was demanding within 7 days of receiving the certified copy of the order. Also, the communication dated 27/8/2019 of senior civil judge Bhubaneswar is on record. From where on record, wherein it is mentioned that the case record in OS 57/1968 are not traceable, which was disposed of on 7/9/1970. So stop. Next. It further transpires that some of the documents were pressed out. How have you examined this? 14/10/2019. Next. Stop. In my considered view, based on the developments subsequent to passing of the order, and particularly the fact that this contempt petition is of 2017, I am not inclined to proceed further in the matter. The contempt proceeding stands stopped accordingly.
183.
No one appears.
186.
Yes.
187.
No one appears.
Item 188.
187 Millard. I am from BC Millard, 187.
Yes.
Millard, in this case, Millard, the contemporary is a 95 years old Millard. And during strike, Millard, he came before this honorable court in person. He argued the matter and interim order was granted in his favor, Millard. But unfortunately, that could not be communicated to the police, Millard. Which he was arrested by the Contempt 2, and on that day he gave the information that the interim order has been passed in his favor. Provided that Millard, he was been assaulted by the police, and also he was heckled by the police, that is Contempt 2, and he was presented before the Contempt 1. And before Contempt 1, the counsel for the petitioner, he gave the undertaking stating there, and also affidavit stating there there is an entry order, and
what can be done now?
Madam?
Nothing can be done now.
Madam, due to paucity of time, madam, the case is pending since 2018, madam. Madam, so cause notice has been given to them, but till that they have neither given any so cause, nothing they have given.
What can be done now?
They have not given any show cause. For what reason they have done?
What can be done now if they say that yes, I violated the order? Then what the court should do?
My lord, they have to give the counter at least show cause.
They are not required to give. They may say that they will not file show cause reply. Then
no, my lord, that is not the fact. Well, the fact that the 95 years old, after showing the
do you understand the questions?
My lord,
what order the court can pass?
My lord, the contempt should be penalized due to violation of the order of this honorable court, my lord. Even though the order has passed in favor of the petitioner that not to arrest him, but he has been arrested.
All right, so
item 188.
In the court's opinion, and after having gone through the reports, and the fact that the contempt matter relates to the year 2012, so I'm not inclined to proceed in the matter. This contempt petition stands dropped. Yes.
188.
Stands dropped. Yes. No, please.
189.
Yes.
One 189 on us.
189.
190.
190, my lord, complied. Speaking order passed.
Complied. Complied.
Item 191. 190.
Non-compliance of the order that the revenues of 1980 to 2016 are still at
Best representation.
the second order, second contempt. We post 10 annex 2 was directed to comply the order.
Yes.
This is greed call is starting, greed call.
Total has been filed, where the sanction order has been given in annexure DY1 of 1,50,000 has been given on the basis that we will submit all the documents before the session and we will take the money matter. This is the.
I have already submitted all the documents, but the thing that not a single power.
Was the employee of safety mode. OP number, was the employee of safety mode. OP number.
Employee of?
OP number 2 and 3 members. I have the OP number 1, where report rehabilitation assistance scheme under report rehabilitation assistance scheme financial assistance of only 1 lakh rupees will be given by now. Sanction order has been given under annexure DY1. And on submission of his documents.
So who is for OP number 2 and 3? Who is OP number 2?
So, and superintendent Kotak and executive.
Who had sanctioned? Who has sanctioned the pension? Who is OP number 1?
RIDCO.
RIDCO. What is RIDCO?
Transmission corporation.
Yes. So he is saying he has submitted.
I have already submitted twice. That occasion will also take time. This is the second one of contempt. First contempt, lordship directed to comply the order, but until later.
Submit your documents. Tell the court on the next date, Friday. Friday.
Before the session and before our sanction order.
I have given all the document.
Do it, do it.
Will it come next week?
Yes, next week.
192.
No instruction.
No instructions.
193.
193.
193.
My lord, we have no instruction.
No instructions.
194.
194, my lord, complied. Speaking order passed.
Speaking order. Give a copy. Complied with.
195.
No, okay.
196.
No instruction.
96.
No.
There are 4 petitioners. Petitioner number 1 and 4, they have already received the block grant. 2 and 3 are not entitled. Orders have been passed. So there has been a complaint.
Complied with.
197.
My lord, the contempt petition may contempt proceeding may kindly be dropped because the writ petition is pending. Your lordship may direct the writ petition will be listed before the assigned bench.
And counsel for the petitioner states that the contempt proceeding may be dropped and the connected writ petition may be directed to be adjudicated upon expeditiously. Stop. Let WPC number 22042 of 2014 be listed before the assigned bench. Both UNTC 1415, 1422 stand disposed of. Yes.
198.
WPC भी दो है. There are two writ petitions, madam. All right, sorry. This is one you are.
198.
एक ही है कंटेम्प्ट है ना कंटेम्प्ट नंबर 1415 of 2020 not 1422 yes non appears
199.
99, my lord. Violating the interim order, my lord. Dated. That is 4/4/2018. Annexure 1, page 8.
so repetition will be taken up.
My lord.
WPC number they list this matter along with WPC so and so before assigned bench.
Item 200.
Cleanings are complete.
Complied with.
200 in person.
Whose order are not complying with it? This is the order matter. Page 10, class 90. The order of circumsolution of directives to review the evaluation of staff between the opposite party and myself.
No, let me see, where is the order?
This is the order of the constitution of the.
Where is the order?
Matter. Page 10, madam. Page 10. The relevance of the tribunal is that the applicant was certified the order passed by the constitution officer Burgos has been allowed in CRP, so 1/2/1990. As per the order.
You are reading page?
Page 10.
Yes.
That order and paying out the order, it is born out of from the record that a specific direction has been given by the joint commissioner holding that the order of past by the relocation of stuff with respect to the case line is void, and this you confirm the order. However, the question of the takes off case up to now the popular matter is not paying out the order of the.
Where is that order?
Order is 19/4 something like that is page 10. Contempt.
19/4.
Yes, sir. Page 10. It is no limited business of the grant of the commissioner. This could dispose of the liquid and directing the paper not treat or could dispose of the liquid after according to the level of possibility of dealing to the all parties concerned and taking strictly according to the law within period.
Yes, so mutation case has not been disposed of.
Yes, madam. These are the order of the consultant, particularly order of the consultant. This order is to be.
No, whether the order has been complied with or not, I am not required to see anything. Yes.
Instruction I have not received, my lord. Just
next week.
Next week.
Item 201.
Nabir.
202.
No instruction.
202, my lord, complied.
Complied with.
203.
203 has become infructuous.
Infructuous.
Item 204.
He also complied, man.
Complied with. Infructuous. Therefore, he is saying, yes.
204.
On appear.
204, my lord, if my lords remember that the case of Suchitra Bhav, that is pending before the Honorable Apex Court, that rehabilitation, whether it has to be covered under the old rule or the new rule. This contempt was filed when the writ petition was disposed of, after disposal. Then thereafter the writ appeal disposed, now the matter is pending in SL.
No, yes.
Well, just admission item 205.
My lord, the compliance has not been done till now, my lord. The GPF has not been applied to the petitioner, the Hindi teacher, my lord. And the order dated 26/3/2004, page 10 of the order. My lordship, the previous occasion directed to State Council to take instruction whether it is complied or not. That has not been compliance or not.
But here I have not received instruction. Your lordship may keep it to next week. I will.
Next week, as requested on behalf of Contempt.
26 minutes. On next Friday.
Item 206.
The order is at page 3. The retirement benefits of the petitioners were to be given by OP numbers 1 and 4. Quoted at begins from page 3. And penultimate paragraph, considering the submissions made and keeping in view the letter issued on behalf of Card Bank for notes and the letter of the MD Postcard Bank, the opposite party numbers 1 and 4 are directed to take immediate steps for disbursement of the retirement benefits of the petitioners as expeditiously as possible, preferably within a period of 3 months. Now, as per my instruction, my lord,
You were employee of what?
of OP number 1, Card Bank.
Card Bank is a private,
No, they are both cooperative under the government.
Card Bank.
Now the problem with Card Bank, my lords, is that it has been liquidated on 31/3/2022.
Then what can happen?
But then the order is towards both. OP number 4 still remains, Ostcard Bank. That is the Apex Bank. And in fact, if my lord would see the counters filed by them,
Now, since the liquidation proceeding is pending or?
it's pending.
Huh?
It's pending. That is vis-a-vis OP number 1. But the Apex Bank, OP number 4, the direction, had it been only vis-a-vis OP number 1, then I would have had to go before the liquidator. This is vis-a-vis the Ostcard Bank also. And Ostcard Bank is very much there. And what they say, Ostcard Bank in its counter says that you pay the dues, we have given you the dues. So between them, they have to now take a call as to the completed right order of this court, and there was a personal appearance of both the managing director of the Ostcard Bank and secretary of the Card Bank. Later on that day, he was the next secretary was replaced. So, and I have also in my affidavit said that since I had during my tenure after getting the order, I have returned to the Ostcard Bank to pay the dues. That I have said in my affidavit.
So your predecessor should be.
I should be exonerated. One but one should be
exonerated, yet they should be convicted.
Before filing of this contempt, I had retired. I retired on 31/8/2011.
You are still in service.
Yes.
You are still in service.
I retired in 11. Thereafter, in 17, the next secretary was implemented. Next secretary is appearing by another advocate.
The second person who has joined Miller, he has also now retired. And he retired on.
And who is the present one?
Now the liquidation process has been initiated since 2022. Miller. A liquidator has been appointed. That is the ARCS Sonpur, Kada Bank Sonpur.
May I file this? I have they are all order of the DRCS liquidation. That my client has collected submit. They are for OP number 1. OP number 4's counsel, Mr. Sahu, he is also there. Now, OP number 4 is the bank which has all the money. They are supposed to, the order says both of you have to pay. So they cannot wriggle out of this order. So OP number 4 may take steps to pay this amount. They are very much
OP number 4, you are employee of OP number 4.
No, that's the Apex Bank. Card Bank is under the Ostcard Bank.
Card Bank cannot be directed.
I bow down to that. Here the direction, right or wrong, it has come against both.
Yes, but what is the direction?
My lord, may kindly see page 3. Page 3. Considering submissions made and keeping in view the letter issued by Card Bank. Now, Card Bank in that letter say that these amounts may be paid by Ostcard Bank. And the letter of the LD Ostcard Bank.
See, everyone is directed, no one has been directed to pay. No one has been directed to pay.
The opposite party numbers 1 and 4 are directed to take immediate steps for disbursal of the retirement benefits of the petitioners. This is the direction.
The steps. So they are taking steps.
But then in the letters they admit that.
And those steps are to be taken within 3-4 months.
That's the order, I cannot improve on that. But the issue is that they are admitting
My employer admits that these amounts are due to us. It's not a disputed amount. Now, opinion
How can that be done? How can that be paid?
Petitioner is a employee of a card bank. Card bank and Oscar bank is a separate entity and a separate management.
Please understand.
And card bank will pay the any dues of the petitioner, not Oscar bank. Oscar bank only
Following-
supervising authority or
Is the order passed by the ordinary bench of this court, violation of which has been alleged in the contempt application. So it is stated at the bar that the card bank Sonpur is under the process of liquidation process. Post op. Oscar Bank is the
supervising bank.
Apex
is
bank.
the Apex Cooperative Bank.
Apex cooperative.
Stop. Mr. Gautam Mishal, senior counsel appearing on behalf of the petitioner, has submitted that Oscar Bank, that card bank is under liquidation, and that would not absolve the Oscar Bank from its liability to comply, to ensure compliance of this court's order dated 17/3/2011. So stop. From the materials on record, we find that the contemners did take steps for disbursement of retirement benefits. So it's a different matter that the retirement benefits have not been paid to the petitioner because of various reasons, including the fact that the card bank is in the process of liquidation. So stop. In such view of the matter, comma, it cannot be said that if there is any intentional or willful violation of this court's order requiring this court to proceed in the contempt proceeding. Proceed in a contempt proceeding. The contempt proceeding is dropped accordingly. Yes.
Item 207.
The petitioner shall, however, be at liberty to approach the appropriate forum or raising his grievances.
Douglas.
Yes.
My lord's order dated 21 June 2024 may kindly received. That the direction by my lord to the state council to give an affidavit as to what steps they have taken when the proposal regarding the regularization of the petitioners on 21st of June 2024.
Here a so-called affidavit has been filed by the university. As against the vacancies available, some of the petitioners have been regularized. But so far as other petitioners are concerned, they approach the government for creation of some vacancy and for their absorption. In the meantime, government also called for the details of these petitioners from the university authorities. They are in the process. Your lordship will grant me a week's time so that I can.
My lord, Mr. B.S. Mishra, he is the senior counsel. He has already been expired, my lord. My name kindly be reflected in that repository. Amsuran for university.
As requested on behalf.
I was granted 2 weeks time to them for state, yes.
This matter on 2 weeks. Yes.
208.
Two orders for us, minor order 28/6/2024 and 12/7/2042.
Yes.
This matter I pray only may be taken up on Friday. It will be.
Friday next.
Item 209.
Last occasion, your lordship directed my honorable friend to go through, they have filed a writ appeal challenging the order of the honorable single judge. As per my instruction, the writ appeal has been dismissed since long. Whether that order has been complied with or not.
Here, my lord, the order passed by the honorable single judge was challenged in writ appeal. Then writ appeal was dismissed for non-prosecution. In the meantime, in 2013, the petitioner has taken a different employment
appointed as Sikha Sayak and his service has been regularized. This is the instruction I have received, my lord. So his claim for compliance of this order no more subsist.
Yes.
Item 210.
Listen, item of 210 lawsuits were pleased to direct me to adopting instruction. Here there is a direction by the Honorable, it's a corporation, a unit of the state Odisha undertaking. There is a direction by Honorable to the corporation to issue no due certificate. Here the employees were the petitioner, they had taken some loan, house building loan from the rural bank, rural housing corporation, which is also state of undertaking. And the amount should have been deducted from the salary and the installment should have been paid. And alleged that the installment was not deducted from the salary and the amount was not paid, for which they received notice from the bank to repay the dues. And they approached this court saying that it is the duty of the corporation, not our duty to pay them off. And accordingly, this court directed the corporation to issue NDC loss, which is not executable because the NDC will be no due certificate shall be given by the bank. However, against a demand of 33 lakhs, 10 lakhs were paid by the corporation and the state government was moved by the corporation because it's a Sikh industry loss, because it's a corporation to remit that 33 penalty loss. And at this time, here I will ask them to take the instruction, also may call it next week so that I can give the concrete news whether the certificate can be granted.
Next week as requested on behalf of the contemporary. Yes.
211.
May that the order dated 29/10/2015 has not been complied with the contempt of mile.
Let's see the order.
The direction was given to supply the certificate of mutation case number
11. Where is the order?
At page 7, my lord.
Annex 7.
Annex 1, page 7.
Page 7. Why, in fact, so many cases I am finding that there is a direction to supply certified copy of mutation case.
But the contempt has filed so cause you can see is 4 paragraph 7. Seeking leave from this court for reconstitution of the mutation case records. But that has not yet been supplied, madam.
So if someone, if the officer is not giving you certified copy, you will come to the High Court. Is there no other forum?
Well, in that mutation case, fraud was committed, for which the petitioner preferred appeal before the supplemental of Bhubaneswar, my lord. And the certified copy of that record is necessary to be enclosed, my lord. For which the petitioner applied for
so many cases,
my lord.
Many of the cases I am finding that I apply for certified
They are not
copy.
supplying, my lord.
What is this? This is not our job.
For which my lord, petitioner has supposed to approach the creditors.
Why is this happening, Mr. Radha?
But last order sheet will also look at yours. Lawsuits, in fact, his grievance has been not redressed. Now we are insisting upon that certified copy should be given because there was a direction that is also that your lawsuit in fact the order the last order lawsuit.
Not that, my lord.
And what stated we can reconstitute not so-called. People also look at the so-called. The Tahsil groups allowed the mutual report of mutation case number before the 12th and the matter is under investigation. And we have
in fact, it was mentioned that it prima facie appears to this court that the petitioner has been misleading this court from the very beginning. If court finds the same to be correct, the court will consider initiation of contempt proceeding against him on the next.
I have filed the reply, my lord.
We have that liberty.
I have filed the reply, my lord.
Yes.
On 15, my lord, on 15/7/2005.
15/7.
My lord.
All right. It is stated by learned counsel for the petitioner that and reply has been filed to the objection filed on behalf of has been filed in this case on
Item 15-7,
15/7/2024,
2004 says, to 24 months.
24, which is not there on record. Stop. List this case on next Friday. Beware. Just, I'm cautioning you.
No, my lord, petitioner has never misled my lord. Petitioner has brought to your lordship notice, my lord, that the certified copy has not been supplied, my lord. They are diverting you other way, my lord.
All right. Yes.
Now, in this case, my lord's direction dated 8/12/2015 has not been complied. In the meantime, 8 years have passed, they are not complying, my lord. On the other hand, they are saying that we cannot comply because there is a resolution of the council that since there is extra employees, we cannot absorb you. Or we will not pay the as per direction of the Honorable High Court. So, my submission that they cannot see the judgment of this Honorable Court, my lord. You have not come for a modification of the order. Now they are saying that we cannot give. That is in their counter they have stated, my lord, categorically stated.
Yes.
And others have also got the benefit, my lord.
Yes.
Yes, my lord. The Secretary of Water Resource Department, who is the head of the institution, my lord, has given a compliance affidavit. The case is not what my lord, and so the case is not like this. Case is that the employees of the Valmi should retire on attaining age of 58 years. The government must enhance the age of retirement up to 60. So that is what means some of the employees of the Cotton Development Authority, they filed a writ application here and there is a direction for contingencies and under the court directed. In this case, kind of transfer that order. Yes. But if you order, my lord, that order which is my allegation is that this order has not been complied with. There.
What is the order?
Yes. Page 3, my lord. Page 3, paragraph, second paragraph, my lord. The order dated 8/12/2015 passed by this Honorable Court in WPC number so and so. Had Mr. D.D. Pradhan and counsel for the petitioner, Mr. D. Nayak, and counsel for the appeal party, the petitioner who as an employee of the army has filed this petition seeking for a direction to the appeal party number 2 and 3 to extend the benefit of the enhancement of the retirement age from 50 to 60 years in consonance with the government resolution dated 28/6/2014, my lord. And now, my lord, I am going to the relevant question last order, my lord. In view of the above decisions, the service condition, revenge decision and other decisions, this has been decided in view of the above decision, the service condition of the state government is made applicable to the employees of the army. According to the retirement age of the said employees should also be enhanced from 58 years to 60 years. Operated by the 2 and 3 have taken steps for approval of the government for the said proposal. The court has already considered the similar nature of grievance in the case of Pramod Panda versus State of Orissa and others reported in 15 to 2014.
The order says, let authority consider the case of the petitioner in light of ratio in case of Premlata in accordance with law. So that decision is to be implemented in accordance with law. So this is their understanding of law.
Yes, my lord. That we have not complied.
But my humble contention, my lords, Premlata Panda case, my lord, this man, what happened? This man got that order, this order was of my lords 2015. The government approved the enhancement age, in the counter the secretary, principal, additional chief secretary stated in the year 2017. By that time, the petitioner was not in job, attained age of 60. For 3 days. That is what they have taken a decision because of the direction of the Honorable High Court. Let us extend them some benefit. To the national increment were given as per the Premlata Panda case management cost 2. Cost 2 and the 2 increment have been already extended. He has already attained age of retirement, cannot be taken back into service. So in this process, my lords, you have been extended the benefits and the order of the Honorable High Court has been complied.
No, no, my lord, in reply to my learned submission,
The Chief Secretary filed.
my lord, in reply to my learned submission, I would like to say, my lord,
Has not been given to you.
because already the judgment of this Honorable Court, which has been relied upon by case,
Sir,
that has been applied.
Judgment of this honorable court had to be considered by them in accordance with law.
That has not been
Their
applied.
understanding of law, they may be incorrect, but they have not violated this court's order. They have not committed any contempt of this court.
This Honorable Court order me, they will follow the decision of Procedural case. And Procedural case says, my lord, I had also made a preparation note, my lord, in 16A, my lord, the employee who leave the court of law is to try to whether impact in their favor or not, shall be entitled to full salary up to the age of 60 years, and age salary shall be paid to them after adjusting the amount which shall be paid. This statement was not complied. This order of the court has not been complied.
According to therefore, the court did not say that apply Premlata Panda.
Whatever judgment is there in the case, that should be complied on its letter and spirit.
No, the court says apply Premlata Panda in accordance with law. So this is their understanding of law. Their understanding is incorrect. But
Panda states has not been complied in my case. I am squarely covered in that judgment.
very difficult.
That has not been covered, not complied.
How many times shall I repeat the same thing? The court did not say apply Premlata Panda case and give him all the benefits. The court said that decide his case, consider his case in the light of Premlata Panda in accordance with law. They have considered your case considering Premlata Panda in accordance with law. Their legal understanding may be poor. They
Well, not ever taken into consideration. That the judgment you have not taken into consideration. And that is the original under Supreme Court judgment.
the operative portion of the order violation of which has been alleged in the present contempt application in view of the above. Sir Lekar. Also, it is not in dispute that taking into account the decision in case of Premlata Panda versus State of Odisha, bracketed supra, this is state.
But I am for the Valmi. I am for the Valmi.
Number one, I also examined the procedure of the judgment.
The contemners have
Those are jointly liable.
taken a decision. First off, taken a decision which according to them is in accordance with law. Next, learned counsel appearing on behalf of the petitioner has attempted to convince this court that in view of the clear direction in case of Premlata Panda bracketed supra, the petitioner was entitled to full salary up to the attainment of age of 62 years.
60 years.
60 years, comma, he being an employee of Valve.
Yes.
Stop. Next. In a contempt jurisdiction, I am not inclined to go into such controverted claim in view of the nature of order which has been passed by nature of the order violation of which has been raised in the present contempt application. The contempt application is dropped. So the petitioner shall, however, be at liberty to question the correctness of decision taken by the contemners by the contemners / state / Valmi before appropriate forum in accordance with law.
213.
Please, Your Lordship. Here, Your Lordship, in the last occasion, State Council took time to take instruction, Your Lordship, for non-compliance of order dated 22/1/2016, operating party, Your Lordship, page 9.
Yes.
Here is super affidavit has been filed.
Yes, page 9.
That is paragraph 5, your lordship. Considering the above, this court dispose of the writ petition with a direction to the collector and district magistrate opposite part number 3 to take a decision on the proposal given by the Tahsildar Baripada opposite part number 5.
Yes, have you done it?
Super's affidavit has been filed by the collector. That is all. Para 6 you will ultimate and receive it proposed affidavit. But the OP number 3 container has highest regard to the order of the and has never ventured to violate the order. Is only submitted the OP number 3 container that is certified copy of the above order and copy of the petition was received soon after receipt of the order. Along with copy of the petition was noticed. Right, notice dated so and amendment notice dated so requested to appear before the OP number 3 container in person in to have the opportunity of personal hearing and to put forth his claim for proper adjudication of the matter. The copy of the notice dated so the deponent has raised that the law has never violated the order deliberate and will the deponent holds the only job so after hearing and on examination of the relevant record, it is ascertained that the land allotted to 12 crack affected persons, including the petitioner, 0.88 decimal of the land in Jungle Kisam, land allotted in the year 1981 for construction of the dwelling house and Jungle Kisam of the land cannot be settled in favor of them unless the Jungle Kisam of the land will not be diverted to non-Jungle Kisam of it. This is how it is focused.
Here, your lordship, that land allotted by them, your lordship. We have constructed our residential house. This is their duty to conversion, your lordship.
To convert forest land into.
My lord.
Then you will have to go to NGT.
Your lordship, my your lordship. Subsequently, they have also stated that their process is going on, your lordship.
So there is no contempt then. They are making attempt.
Yes, your lordship.
There is no deliberate violation. The petitioner.
Your lordship, in their affidavit, your lordship, page 8, your lordship, they have stated, so after receipt of DGPS mapping of the land in question, they have resubmitted the diversion proposal. They have resubmitted, but they are not taking further step to finalize that, your lordship.
The petitioner has alleged disobedience of this court's order dated 22/1/2018, passed in WPC number 19534 of 2015. Whereby the said petition was disposed of with a direction to the collector from district magistrate, which place? Baripada, to take a decision on the proposal given by Tahsildar Baripada for what was the proposal? For de-reservation of 0.88 decimal of Jungle Kisam land for rehabilitation of 12 crack affected. What is crack? Crack in the.
That is initially they are residing before a river bank LLC. Subsequently, due to landsliding, they have resettled there.
Craig affected persons. Stop. It is the stand taken on behalf of the state that steps have been taken and competent authority has been approached for grant of grant of no objection. What do you see? Grant of permission to divert the forest area into
Non-jungle kisam. Diversion of jungle kisam of the land to non-jungle kisam.
jungle kism of land to non-jungle kism of land. So stop. But they must be the residents, they must be poor people.
Yes.
How can you ignore them? Where will they go?
Here they have moved to the government of India because government of India is the competent authority to divert the jungle kisam of land to non-jungle.
See, Mr. This writ petition was filed in 2015. And in 2024, your government of India has not done anything.
Para 10 of the SOCO's affidavit may kindly be secured. Para 10 they have.
How many persons are there?
There, I cannot see that in 12% they have settled in jungle kisam land LLC. Other 2%, they have settled that is no, they have no any objection.
Circumstance where they cannot live in jungle kisam land.
Indicated in para 10. So that it is not within the capacity of the collector who will take that decision. So they have referred.
So you want this court to take suo motu notice? I can convert this proceeding into a writ, contempt proceeding into a writ proceeding.
Move the central government. That is what.
Sensitive. They should have taken. So if it comes to their transfer and this thing, they take a lot of interest. But when it relates to the poor people who are required to be rehabilitated, you don't have any interest.
Let it come next week, next Friday. I'll obtain instruction.
Tell your collector.
Regarding further development.
Please tell your collector.
I'll take.
Stop. The stand which is taken by the contemners in the so-called affidavit is not at all satisfactory. Stop. List this matter on Wednesday. It is not done. Where will they go?
Item 214. Well, 214 order has been complied. 215.
And 215, I am on DC my lord. I am for the petitioner. The connected review application which was dismissed on 2019 may be restored. I have no objection, my lord.
A review petition?
May be restored, my lord. I have no objection.
Honorable High Court directed to allow the adjourning land to the petitioner.
No, review application has been restored or
application has dismissed for compliance of the directive to Honorable High Court, serving the council. Because they solved that topic, that is what also
where is your application for restoration? Why didn't you file a separate application? SI number 45 of 2024 has been filed.
23, man. 45 or 23, man.
45 of 2023 has been filed for restoration of the restoration of RV is complete, so and so. Which IA number? Oh, this is to dismiss for non-compliance or dismiss for removal of the defects. So, in the considering the facts and circumstances, in the interest of justice, this application is allowed. RVP so and so times restored to its original file. Yes. Let the contempt listed along with just listed along with RVP number so and so before appropriate bench.
216.
216, no instruction.
So order has been completed because I've also look at all orders have been completed.
No instruction complied with.
217.
The 2017 order has been complied with and just after it has been filed in 2017.
Complied.
Your lordship can have a page 18 of the content petition.
But it says the order has been complied with.
That order matter. This court further directs that since the petitioner was continuing under suspension all through, he is entitled to substance allowance all through and outstanding, if any, on this head, be released in his favor of the petitioner forthwith. They filed a show couch indicating that they have complied. Minus, I have filed a reply to the show couch. The amount which I am entitled to ask for the order of the lower court amounts to about 24 to 25 lakhs. They have given 4 lakhs. That
you can.
I was giving you so that
learned counsel for the and senior counsel appealing on behalf of the petitioner.
the guys of compliance have given
The subsequent development does not press the present contempt application, but seeks the liberty to raise grievance before appropriate forum in accordance with law as regards less payment of subsistence allowance than what he is actually entitled to. The contempt proceeding stands stop with the liberty as sought.
218.
So 18 years also may take it up next to because also had directed to obtain instruction. Tahsildar Puri was Puja, he was busy, so only next week I can obtain instruction.
2018 next week.
219.
1 week, your lordship.
1 week.
220.
220 focus 5 years order has been completed.
On the years.
221.
The running page 4 university have grants. The order passed in the WDC number 13,384. The
order has been complied with or not?
Here, my lord, before disposal of the representation, they should have given the opportunity of hearing, which was not given. No letter was issued to that effect, and no hearing was done. So how they disposed of them?
What was the direction?
The order is, my lord, at page 4. Considering the submissions made and without expressing any opinion on the merits of the case, this court directs appellate part number 3 to dispose of the representation dated such and such, filed by the petitioner under Annexure 2 in accordance with law within a period of 3 weeks from the date of production of certified copy of this order after giving a reasonable opportunity of hearing to the petitioners and after perusing the report prepared by the RI Japa with regard to demarcation of the board.
Yes.
But I filed a complaint affidavit also can look at.
Did you give him hearings?
No, sir.
You should have courts in all the offices.
I have not specifically intimated that no construction is only representation has been communicated, but I have never said that whether no opportunity hearing was given to him or not. That if I will find out whether he is given notice or not, that I will say also.
Here in their compliance report, my lord, they have annexed 2 annexures
No, but they have done something. They have passed.
But we are not, neither any petitioner has received.
Challenge that order. Hearing. Is there any statutory requirement of hearing?
The hearing necessary since the.
Is there any statutory requirement? Whether any statute provides personal hearing?
As you worship, please.
No, I want to know from you whether there was any statutory requirement for personal hearing.
Personal hearing is necessary. They are telling that the petitioners have no land to the adjacent of the road. It is.
Sir, he was communicated to the petitioner by the executive lawsuit 2017.
In the present application, alleges disobedience of an order of this court dated 5/8/2016, passed in WPC number 13384 of 2016. First off, by the said order, this court, without expressing any opinion on the merits of the case, had directed opposite party number 3 in the writ petition to dispose of petitioner's representation dated 13/6/2016 within a period of 3 weeks from the date of production of a copy of this order, after giving reasonable opportunity of hearing to the petitioner and after perusing the report prepared by the RI Japa with regard to demarcation of road. First off, compliance affidavit has been filed stating therein that petitioner's representation dated 13/7/2016 has been disposed of. When counsel appearing on behalf of the petitioner, however, submits that the petitioner was not given an opportunity of hearing as was directed by this court, and therefore this court's order cannot be said to have been fully complied with. First off, next, considering the circumstance that the opposite parties have passed an order on the petitioner's representation, I am of the view that the contemners apparently did not have any willful intention to disobey this court's order. First off, in my considered view, no case of deliberate disobedience of this court's order is made out. So the contempt proceeding stands dropped accordingly. First off, it goes without saying that the petitioner shall have liberty to question the correctness of the decision taken by the contemners on the petitioner's representation.
There is some opportunity. Opportunity given.
Mr. If in each and every case we direct the authorities to give personal hearing, then even the circle officer's office will have to have a courtroom. All right. So every officer should have a courtroom, should give. The personal hearing is required when the statute requires. When the statute doesn't require, then where is the question of and personal hearing disposal within 3 weeks for peruse the records? Here means not here, you only, others also. So this contempt application, these contempt applications are pending before this court for last 11 years. And we require them to consider within 3 weeks. So they have done something.
Beg pardon, my lord. 220 are there.
What do you want?
Item to number 220, my lord.
What do you want?
Just I
want what do you want in 220?
The order has been passed, I don't know what.
All right, order card, no one appears card. All right.
That is not complied.
Order not complied?
Not complied.
220?
No, not complied. My lord, see.
Sir, if the case is here, please ask someone to be here when the case is called out. Next Friday, karo. Special list.
arbitration matters.
Lordship, I made pardon to mention, Lordship. Item 216, some other counsel just appeared and said no instruction. It was supposed to appear in item 215. But he said that no instruction. So there's some little bit confusion in that matter. Item 216, Lordship.
I would be pardon.
Lordship, I just listed next week. I'll just there was a hearing.
I would be pardon to mention number. Item number 331. It was last week it has been installed on 19, but it could not reach. Coming week, this may be so that it can take up seasonal distress levy and the matter is to be taken up.
Which year?
2024.
So when did you file your contempt application?
Yeah.
It will be taken up. See, we are taking up 2014 matters.
Well, she will need up for 10 years the money, but she is starving and she need to be taken up.
I'll see.
Obliged.
One specialist, one arbiter. Sorry, arbitration to face admission. Arbitrator failed to appoint presiding arbitrator. Specialist face admission item number 1, ARBP 18 of 2024.
Yes, I'm not ready, Mr. to deliver. Let it come on next Friday also.
Item number 2. The bail that one. Item number 2, ARBP 25 of 2024.
Well, it's here, the arbitration clause is at page 59, resolution of disputes, and we have served a notice for appointment of an arbitrator. Annexure 6, my lords. Notice has to go out.
So notice.
Obliged.
Item number 3. Clause.
Yes, so notice.
Yes. Item number 4.
Requisites within 3 days.
Item 4.
Item 4 is an application filed for change of arbitration. After it has been appointed and already arbitration proceeding has been commenced. But here what I was saying on the last occasion, you also but
now in view of the Supreme Court decision, what can be done? You apply, you withdraw this and you file your application.
I have not, he has filed that.
You withdraw. In view of the Supreme Court decision, nothing can be done.
My lord.
Counsel for the petitioner seeks permission to withdraw this application with the liberty to make an application before the learned single judge, district judge, who is the principal judge of civil jurisdiction, in the light of the Supreme Court's decision. In case of, do you have that order?
My lord. My lord, Chief Engineer NHPWD. I'll just check. I'm not getting, I'll just supply. I'll just supply it now.
Item number 5.
Item number 5. In arbitration petition number 9 of 2023, this honorable court, wide order dated 12/5/2023, directed both the parties to appoint one arbitrators each, and those two arbitrators will appoint an umpire.
In this case, Your Lordship, there is a failure in arriving at a consensus with regards to appointment of the umpire, Your Lordship. Hence, because the opposite parties are not cooperating for the appointment of the umpire, I was compelled to file the IA number 2022 of 2023, Your Lordship, seeking proof for the modification of the previous order passed and for the appointment of the umpire, so that the arbitration proceeding can begin.
Which provision?
Under Your Lordship, the section 11, subsection 4, as well as under subsection 6, this honorable court is empowered to appoint the umpire if both the parties fail to arrive at a decision with regards to whom the umpire would be. In subsection 4, Your Lordship, point B, that is, if as well as subsection C.
4B is something else. 4B gives you call of action to approach this court under 11.11.6.
Under 11.6, Your Lordship, under subsection B also, there is a procedure that the parties, if both the parties are not cooperating with each other, then this court also has the power to appoint an umpire, Your Lordship. That is my understanding, subject to Your Lordship acceptance, Your Lordship.
Should I appear for the respondent in this matter?
Yes.
Firstly, my learned friend's contention that there is a failure or that any party is cooperating is absent. The meeting could not be held between the arbitrators and they could not concur. That is not because of any disagreement, but because the efforts were not made, the meeting has not been held. There is nothing on record to show that there is any disagreement. If Your Lordship only sees the IA, it requests the court to appoint a sole arbitrator.
Suppose there is any disagreement, then what course is to be adopted?
Lord, if there is a disagreement between the two appointed arbitrators, then certainly the presiding arbitrator can be appointed by the court. But for exercise of that power, something has to be brought before the court.
Yes, what's there? How do you say that there is disagreement?
There is no disagreement.
My Lord, pursuant to this honorable court's order, the appointment from the side of the petitioner as well as appointment on the side of the opposite parties were appointed. A meeting was fixed for the said discussion for the appointment of the umpire.
You can apply for change of the arbitrators if you also.
But Your Lordship, if my IA may be produced and the documents that I have attached.
No, we have filed IA in a disposed of matter.
Yes, Your Lordship.
This practice we should dispense with. This practice is not the correct practice.
One more aspect, my lord, if Your Lordship sees the IA, the prayers in the IA, my learned friend is requesting the court to appoint a sole arbitrator, which is contrary to the agreement.
How can you say that?
My Lord, if I may be just permitted, Your Lordship.
IA number 22 of 2023. This application has been filed for modification, has been filed with an assertion that the two arbitrators appointed by this court,
no, Your Lordship, the parties have appointed.
Appointed by the parties have not been able to appoint an umpire.
Yes, Your Lordship.
First off, this application has therefore been filed for appointment of an umpire. So stop. When counsel appearing on behalf of the opposite party has submitted that there is no document on record to demonstrate that any meeting has been held between the two arbitrators and that there is any disagreement between them over the appointment of the third arbitrator. First off, next such view of the matter, we do not find any merit in this application, which is accordingly dismissed. Yes.
Item number 6.
Well, see, item 6, I am appearing for the opposite parties. I have already filed my Bakalatama yesterday. So I'll file my objection. Yes, sir, was not that, but I have already.
As your lordship reasons, but already there is an advocated there's an arbitration clause. Is it, if my learned friend is disputing the arbitration clause, then he wants to file his objection.
File.
I'll file my
4 weeks. Time is allowed for the opposite party. You call it opposite party or?
All the opposite parties.
Opposite party to file objection to the application under section 11, section 6 of the arbitration consideration. Yes.
Okay, great. Item number 7.
Item 7, your lordship, in this case, my lord has been pleased to issue notice. And notice has been sent, but it has been returned undelivered because of not correct address. Address is not been furnished. In fact, in the agreement, the same address is given. I'm trying to search out address. My lord may allow some time.
Press 2 weeks.
Item number 8.
My lord, when you issue notice, and after the one, but notice has already been duly served as per the endorsement of the postal already. But man, of course, on 2/7, 2024, notice have already been served.
Someone has appeared.
From tracking report.
The notices are said to have been validly served upon the opposite party. But no one has entered appearance. In this case, on 2 weeks. Appearing, awaiting attendance of appearance on behalf of the opposite party.
Item 9.
2 weeks.
Item 9, your lordship, the opposite party has sent the wakalatnama through registered post. You will file it by Monday or by Tuesday, your lordship. You haven't
As requested on behalf of the opposite party. Has submitted by, what is the name?
Yes, Suchita Himansu.
It has been stated by so and so that she has been instructed to appear in this case and is expecting a wakalat, duly executed wakalatnama on behalf of the opposite party. So, place this matter on 1 week.
Yes, your lordship.
Item number 10.
Item 10 minutes, I am appearing. On the last occasion, the learned from the government state of Odisha had taken time for filing of counter. As of now, no counter has been submitted. Only 2 dates they have taken. 2 dates in the meanwhile has passed out, but no reply has been filed. There is no objection to the arbitration clause because it's a government agreement and there is no objection to the arbitration clause. Nobody is appearing, I think. They have some Mr. Mahanti had given his appearance, but he's not appearing.
Who has given appearance?
Yes, my lords.
Who has given appearance?
Mr. Rishwar Mahanti. Mr. Mahanti. He was the ASC by then. There is no objection to the arbitration clause.
There is no representative on behalf of the state. On behalf of the opposite party. What's up? Do you have any name in your mind?
Lords, Durga Prasad Nanda. He's a senior advocate. He is in
the panel.
If he's there in the panel, if he's not, my lords, I'd play Gautam Mukherjee, senior advocate Gautam Mukherjee. He's there in the panel. I know.
I don't know. Who is appearing for the other side in this case?
Justice, then my lords, Ramakant Mahanti, Mr. Ramakant Mahanti.
No, but no one is there on behalf of the estate. I want to have his consent also.
Lords, the only thing I can delay.
Why is it
2 dates have
Why there is no representation on behalf of the estate in arbitration matter?
This matter, my lord. Is that for the state, my lord? I don't know this file.
He is not, said that Mr. Mukherjee, you won't have any objection. What he proposes.
Mr. Mukherjee's name is may be better be appointed, my lords, because he's there on the panel also. We might have the Mr. Nanda, I think he's not in the panel. Mr. Mukherjee may be appointed. Small claims.
Let someone appear for the estate, otherwise.
Mr. Tarun Patnaik's file is there.
I don't know what happened to him. He is supposed to appear before. All the criminal matters are assigned to me.
Mr. Let us wait. Let it come on next Friday.
Next Friday.
Please inform him. It's very important for you.
I will inform him. I'll inform him by tonight.
Inform him that you have suggested whether he consents to that or not.
Item number 11. No, please. This was for naming of the arbitrator with the consent of the party. With the consent of the parties, my lord wanted to name the arbitrator. We suggest Mr. Ramakant Mahanji, senior advocate, my lord. His name is in the panel.
Mr. Ramakant Mahanji. Yes.
Item 12. I am here for the petitioner. Yes, you understand.
Next, I have filed an affidavit as per instructions of our client Contempt. This filed an affidavit that bringing to your lordship's minutes notice that the as submitted in the last occasion manner, the talks are really at an advanced stage. The talks of mutual settlement are really at an advanced stage. Lordship, can you refer to page 4? Or I'll read the understandings which have been done as the instruction. You have
Why should I see? I have very keen efforts to resolve it amicably.
That's true, Lordship. What has happened since August 2023, this process is continuing. Nobody is coming to a final conclusion. Whenever some decision is taken, on the next day that decision is reversed. Another new issues coming. So therefore, we do not find really that the settlement would at all achieved. Because for the last 7-8 months, another important aspect, Lordship, really found that the settlement process did not come to an end. What do? You have to file an application under Section 9 for protection of my equipment. It's a high-level equipment, 3 crores. But even then, neither the equipments were returned, no settlement was arrived at, my payment was held up by them, I was restricted entry into the work site, everything is in roll down stage. Yes, I agree, talks are continuing, but it is not being fructified, no signed agreement or
what is your suggestion?
My suggestion, Lordship, will be, my prayer is that let the matter be referred to arbitration. Lordship may kindly consider to appoint an arbitrator. After that, if it is settled, it can be settled anytime. That's my simple.
This is very right. Like, if you want to settle, that can be settled even during the pendency of arbitration.
That's right.
Ideally, this matter should be kept pending.
I foresee no difficulty there, but only that if it could be settled out of court in the.
No, it will even, the court is not going to settle it even otherwise.
No. I get your lecture's point. Just to
you will have more time outside the court.
No.
Once the arbitration proceeding is disposed of, you will have enough time.
No.
When the arbitration is, so just suggest the names.
Might well be from this line.
You just tell the name.
Just in Vishwajit Mahanti, Justice Vishwajit Mahanti.
Justice Vishwajit Mahanti.
Much obliged.
Item 13. Last hearing, I suggested the name of the senior counsel, but that was not acceptable to my learned friend.
I talked to the friend, they are agreeing for the which judges, the name of.
Not district judge, I am suggesting the name of Justice M.N. Das. Retired judge of this honorable court, I don't think my learned friend can have any objection to it.
Again, I put it was with 3 crores only.
No, not 3 crores, it's more than 6 crores.
So I have suggested for.
Not a district judge, I will not agree to a district judge.
I will send the offer.
The court will not.
Justice M.N. Das or Justice Pramod Patnaik, your lordship may take Item 14.
Item number 14, in this case, I am for the opposite party. In this case, I am for the opposite party, my lord. I pray with the lordship and 1 week time be given so that I can file a counter to this, my lord. 1 week time.
Yes, your lordship.
As requested.
Item 15.
Filing the objection on the question of limitation, my lord. I'll serve a copy of my learned friend respect to this matter to the expert.
Appealing for the petitioner.
Not here. I'll serve a copy of the load and file this in the registry, the objection.
Who is appearing? One appears on behalf of the petitioner, plus this matter on.
Mr. Jivraj, carry to the appealing, my lord.
Item 16.
Item 16. I am for the petitioner.
Item 16, your lordship, I'm appearing through virtual, lordship. Today only I filed the Wakalatnama on behalf of the opposite party, your lordship. May I pray, lordship, can grant me 4 weeks to file the counter to this matter.
Counter on what? Are you opposing?
Yes, I'm opposing to this petition, your lordship.
4 weeks time is allowed for the opposite parties to file.
Sorry, one.
For opposite party to file a counter affidavit. Let's this case on 4 weeks.
May I pray the petitioner could serve a copy on me, lordship.
Yes, sir.
I will. Item 17.
Thank you.
Your lordship, I'm appearing for the petitioner. Your lordship, the petitioner was in abroad. Therefore, your lordship, we couldn't communicate with him. Therefore, your lordship, I humbly pray that this item may be kindly taken up next week, your lordship. 1 week time, I will give.
Yes, minutes. I'm filing the appearance minutes.
As requested on behalf of the petitioner, this matter on 1 week. First off, the opposite party has entered appearance by filing a Wakalatnama, which has been taken on record.
Item 18.
Plus item 18, also they had taken time to file their response. No response in this matter has also come up.
Again,
it was there in the last week. Same state, Milords, Department of Water Resources.
Arbitration matter. 330 arbitration.
Time will go to that. Item 19.
My lord, in item 19, I am for the petitioner, my lord. But the name has been indicated in the list. The name hasn't been in the list, so kindly matter in the list to another date. With the notification of the name of Mr. Prasanna Kumar Nanda.
So,
Prasanna Kumar Nanda.
So what do you want?
They are seeking time that the council's name has not been indicated. They have filed the Wakalatnama.
Let name of counsel representing the respondent be reflected in the cause list. So stop. List this matter on 1 week.
No. No bless.
Additional. Additional specialist. BLAPL 14716 of 2023.
Yes.
50 kilos of Gandha. I think from 2-3 occasions my friend is absent. 150 kilos of Gandha also. From client. Who it will pay also will get
This is the today also there is no representation on behalf of the petitioner. So, considering the order sheet, it transpires that the Netherlands Council for the petitioner is not interested in pressing this application. The application is accordingly dismissed for the
Item number 2.
Yes, what is the offense?
That my case is also 20B2C of the NDPS Act. 20B2C of the NDPS Act. That here my letter, the first petitioner, that item number 2.
Recently, I passed an order taking into account the Supreme Court's decisions, including the latest passed by Honorable Mr. Justice Suryakanth.
My case is it's my case is something different. My case is
Yes, like you are sitting in the bus and you pointed out,
this is the
and your lady is therefore you are not aware, and therefore
my case is this petitioner number this petitioner is a lady nothing was seized from her possession. Then this is the prosecution case that
nothing was seized from her possession.
No, not from her possession. It was seized from the possession of.
We understand from beneath the seat. From beneath the seat.
No, not actually not beneath. And he subsequently disposed of the passenger. There are two-fold. My submission is two-fold. First of all, while if your lordship will see the FIR, this informant who was investigating another case of 379 411 cases, he got information, and getting information regarding transportation of contraband, he went. So getting information from the FIR end, he has not complied with section 42 of the NDPS Act, that has not been 42 section 42 has not been complied. Then that is appearing from the record. Section 42 has not been complied. Then he went and search. He found that the contraband ganja was kept in the bag of the another accused. So this petitioner is been implicated on the one is on the confession of the co-accused, and nothing has been seized from her possession. From the possession, it's item number 3. Similar, I'm not listening for that person. Consider. But so far this lady is concerned, there is no other material against me. So when there is substantial, there is no, first of all, there is no non-compliance of section 42, which cannot develop since charge sheet has been submitted, that cannot develop. So that itself will initiate the proceeding. So that apart from that, my submission is nothing was seized. from my position.
You see, call for the case diary.
Item
Yes.
Three mirrors connected, item 2, 3, and mirrors 5.
I are all connected.
Same connected.
Let the case diary come.
4 weeks.
4 weeks.
Item 4.
Item 4 permitted to withdraw matter.
Item number 6.
I do not see my lord, can you take from next week? I prefer 1 week. My lord, Mr. Rogada was appointed as AGM, my lord, rallies with him, my lord.
The probation under Sagana. I'll grant you time, but I'll cancel his bail.
My lord, next week I will be prepared. Next week.
Grant counsel for the petitioner. Former by way of last indulgence. 6. Adjournment to next Friday. Sophie has assured this court that on the next date, he shall make his submissions.
Only sir.
The item progress. Now, out of taken.
Mention next Friday.
I will another problem, my lord.
You are alleging violation of an order.
Except Friday. I don't have control.
You have alleged violation of order passed by this court. What was the order?
Order number
What was the direction?
violation to comply board of amendments.
What was the board of revenue order? Allowed what? We want to know. All right. Next week. He is not interested. The petitioner is not interested. His sons are interested. Yes.